All right, test 1 2, test 1 2, check, test 1 2. Test 1 2, check, test 1 2, test 1 2.
Good morning, Phil. 1, 2, 3, 4, 5.
Check, test 1 2 3 4. Okay.
Well, good morning, everyone. Welcome to another WILMIC Summer Seminar. This is now our, probably 12th, 13th, 14th, something like that. So we appreciate you being here. We also want to welcome those of you on the web who are watching live. This seminar has been approved for 3 ethics credits. And for those of you on the web, you will notice on your screen there will be a question tab. If you click on your question tab, you will be able to submit questions and comments to us. Feel free to do so. I will get those up here on my mobile device, and we will read those to the audience here, and we will talk about that. And for those of you here in person, feel free to raise your hand and jump in at any time, and we will entertain questions and comments from you as well. All right, so let's get started. This 3-hour program is divided into 2 sessions. The first session here is going to be devoted to bankruptcy and collections, FDCPA work, things of that nature, and then the second half will be devoted to estate planning. Bankruptcy and collections work, as well as estate planning, have been areas of practice, as Matt will tell you, that we've seen an increase in claims, and we'll talk about why and what is happening out there. So away we go. I want to introduce our 2 speakers for the first half of the program. To my immediate right is Matt Beier. Matt is a claims attorney at WILMIC. He joined us last year. Prior to that, Matt was a civil litigator in Madison for a number of years. He graduated from UW Law School in 2000? 2000, okay. So welcome, Matt. And to Matt's right is David Krekeler. David, of course, is a longtime and well-known bankruptcy and collections attorney in Madison. David is the founding principal and shareholder in the firm Krekeler Strother. He devotes his practice, of course, to bankruptcy and debtor-creditor issues, including FDCPA and the Wisconsin Consumer Act. So we're delighted to have both of you with us this morning. So let's get into it. I mentioned that bankruptcy and collections work, and FDCPA work for that matter, seem to be climbing on our hit parade in terms of claims. Matt, the last 2 years we've seen that trend, correct? And I guess if so, why?
Well, tough to say, other than, well, let me just talk a little bit about what we have seen. So it's been since 2009 that we've seen a fairly marked increase in claims in the bankruptcy collections area. Estate, trust, and probate claims have always been probably in the top 5, although they now take bankruptcy collections is one category. Estate, trust, and probate as the second category are the top 2, and they have been for the last 2 years. In 2015, 30% of our claims were in the bankruptcy collections category, and 17% of our claims were in the estate, trust, probate. And that sort of evened out in the last year, so that in 2016 they both have an 18% share of our claims. So that gives us pause for concern, and we want to address, why those things are happening. I think a large part is that there is some familiarity in the plaintiff's bar with the consumer protection statutes out there, the Fair Debt Collection Practices Act and the Wisconsin Consumer Act, which we'll talk, and David specifically will talk more in detail here as we go. But what is it? And that's really the purpose of this discussion. And if I can just echo Tom's comment earlier, that this is a fairly informal discussion. So if at any time you do have questions, please point us in the direction of the things that you would like to talk about. So I have taken a look since I have been at WILMIC at trying to drill down and figure out some of those root causes. And I think there are 2 things. One I mentioned briefly, and that is some familiarity with the consumer protection statutes that are out there. And second, we have a lot of debt in this country. In its overview of the debt collection market, the Consumer Financial Protection Bureau reports that it expects consumer debt to grow, with increases in the student loan segment of the market driving the growth. I think many of us are familiar with our own student loans, or perhaps our kids' student loans. and that certainly gives rise to collection actions because they don't always get paid. And so as the debt increases, so does the debt litigation, so does bankruptcy. So I think those two things are probably the biggest factors that contribute to the rise in claims: the familiarity with consumer protection statutes and the rising debt. David, do you have anything on root causes?
Yes, I agree with what you're saying. And in fact, when you talk about the rise of debt, I noticed you checked the CFPB, Consumer Financial Protection Bureau. I happen to do the same. And the reports out now are that consumer debt is approaching almost at its 2008 level at the time of the recession. The makeup of the debt is far different now. Then it was a lot of mortgage debt. We're replacing that with auto debt and other unsecured debt, including the student loan. I'm not saying we're on the verge of a bubble. I'm not smart enough to know that. But certainly debt does drive it. But there's also a lag time. So when people take out the debt, they're not in default right away. It takes a while. And so I think one of the reasons you're seeing the increase in claims now is because when the recession hit, bankruptcy became a boom industry for lawyers. I know we couldn't even keep up in our firm with all the work. And I think that a lot of lawyers who didn't practice in that area very much jumped into it. And we saw the same thing in the housing industry. Think of all the claims there were against mortgage brokers and mortgage bankers after the recession hit, because real estate sales and refinance had been growing at such a rapid rate that there were new people, untrained people in that industry who made a lot of mistakes and then later got sued by people like you and me for those mistakes. I think the same thing happened to some degree in bankruptcy, that after the recession, by 2010, people realized this is a growth industry. Lawyers who weren't familiar with doing bankruptcy started doing this work, and mistakes come when you don't always, when you're not fully immersed in the area of practice that you're in. So I think that's one of the reasons. Another is just more exposure. There is so much more knowledge about these things today, and you touched on that. But for example, the CFPB is in the news all the time. You just got statistics, I got statistics. It didn't even exist in 2008. Competition. Now bankruptcies are way down. We've had 26 straight quarters of decreases in bankruptcy filings. So now people who don't do a lot of bankruptcy work are getting out of it and looking for other things to do. And bankruptcy lawyers who aren't busy are looking for other ways to complement their practices and stay busy. And some of them are doing more debt collection violations. A number of them are. In fact, there's a very bright young lawyer here in our audience who I was talking to right before we started, Zishan Usman, and Z was telling me that he's doing a lot more of this because the bankruptcies are down. So if lawyers are experienced, good lawyers are looking for violations, we will find violations because they are out there. So I think that's four different factors that lead to why the claims are up in bankruptcy and debt collection.
David, why don't we get into some ethical issues involving collections? There are many, so why don't you touch on some of those?
Well, there are many, of course, and we just talked about one, and that's competence. If you're going to be doing this work, bankruptcy, especially bankruptcy, as opposed to debt collection, is a code-driven practice. It has a lot of intricacies. I sometimes have to explain to my clients that what I'm about to tell them may go against their normal grain, that a lot of what happens in bankruptcy is inside out and upside down from the way people normally think. And it's also different from the way lawyers sometimes think. So the first thing is, if you're going to be doing this work, invest the time and really get to know it. There is an abundance of seminars and learning opportunities when it comes to bankruptcy. I'm the past chair of the bankruptcy section, and I know that we have an annual update. We have February Follies. We have a day-and-a-half retreat at Kohler. The Western District Bankruptcy Bar has 9 lunches a year, and for the cost of lunch, you also get a CLE credit. The Lou Jones Breakfast Club is televised, not everywhere in the state, but it's Milwaukee, Madison, Green Bay, Appleton, and maybe somewhere else. That's free, no cost CLE, and that's probably 10 or 11 times a year. So not counting anything else, and there always are other things as well. The State Bar just did one on bankruptcy and tax. There is an abundance of opportunity to learn, and a lot of it is free or next to free. So there's no reason not to immerse yourself if you're going to be doing this work. When I was thinking about what kind of ethical issues arise, I think it arises in a couple of contexts. One is conflicts of interest. We know that comes up at every ethics seminar. It comes up a lot in bankruptcy, particularly in a practice like mine where I'm dealing with small businesses and farms, because it may be an LLC or a partnership that owns the farm or the business, and the finances of the entity are intricately interwoven with the finances of the principals. So we have to be careful there about documenting what we do. I don't have a problem with representing the owners of a business, depending on how many there are, but a husband and wife that own a business or a farm and representing their LLC, but I still go through all the disclosures about it. And I want everything covered in writing. It becomes more difficult. Yesterday I met with a young farmer who is in business in an LLC with his brother and his father, and they have several businesses. They've got a crop growing business and a grain drying business and about 4 different entities. That is well beyond the scope that one law firm is going to be able to handle. Now, there are ways you might be able to do that. I have a situation where we collapsed all the entities into one so we could do a single Chapter 11, but otherwise we have to be very cognizant of conflicts of interest here. And you really, if you're still doing your conflicts with your head or on paper, you're probably making a mistake in debtor-creditor law, because when you start getting into any cases of magnitude, there are a lot of creditors, and we have to be careful about that. So from a debtor's perspective, usually it's conflict of interest that we worry about first. From the collection side, from the creditor's side, there are some fairly unique issues, I think. Oftentimes, if you're doing collection work, you're going to be dealing with unrepresented persons. And there is a Supreme Court rule on that, SCR 20:4.3, that lays out how you have to treat your dealings with an unrepresented person. And actually, Wisconsin rule is somewhat different than the model rule. It goes a little beyond that. The safe harbor there is, if I had to give you just one sentence of what you should do, it is give no legal advice. That would be the worst thing you can do. You should always identify to the unrepresented party that you are a lawyer, identify what your role is. I'm here to represent my client. I'm here to take judgment against you. I cannot and will not give you legal advice. By the way, the rule says you can give general legal information. I would try to, because memories are fleeting, if I'm going to give any, I would like to put that in writing. So anything, if I'm dealing with an unrepresented person and I tell them anything, I'm going to send that with a follow-up letter or email. Confirming what that is so that their memory later is not different than what I believe I told them. About the only legal advice you should give an unrepresented person would be get a lawyer. But the main thing where we see the problems that come up with ethics complaints, grievances, is when the lawyer for the collector is giving any kind of legal advice. And then later, the unrepresented person feels they've been wronged, they lose the case, they're bitter, and next thing you know, you got an OLR call saying, what are you doing giving legal advice here?
Let me just offer a couple of comments about the points that David just made, and these are David's thorough discussion is on page 33 of your outline. If you'd like to read more about the rules that he mentioned and some fact scenarios that deal with the ethical issues that he raised. The first one that he mentioned was competence, and I guess, from a malpractice carrier's perspective, I think we ought to offer this: don't dabble. That's a difficult thing to say to solo and small firms because a lot of times you have to run a business too, and you have to be successful. And simply saying don't dabble is not very helpful to you and not very helpful to your client. But I think David said the smartest thing, which is to make yourself, or to avail yourself of the knowledge that's out there. Talk to other people. Call David. He'll talk. And he'll share whatever experience he can with you. Call me.
I will do more than that. I will, if you call me, I will meet you, I will buy you coffee and a bagel or Danish. It's on me to give you free legal help. And I'm happy to do it.
I'm just good
There's
for
now
coffee.
a record of that.
But for real, don't dabble because you'll find yourself. Yes, the bankrupt. I think everybody knows that the bankruptcy code is one that's very complex, and you need to have been doing it for a while, or at least be surrounded by people who have been doing it for a while to do it well.
I think statistically, at WILMIC, what we've seen over the course of many, many years is that over a third of our claims come in areas of practice in which the lawyer has reported to us on their application that they only work in that particular area of practice less than 10% of the time. So that kind of tells it all right there.
Yeah, the claims will come if it's not an area you're familiar with. The second one that he mentioned was conflicts of interest, and that can arise at any time. In the collections field, there are firms who sometimes get confused about who they represent. Are they representing a collection agency who is referring that matter to them, or are they representing the original creditor? It's always the original creditor. But just be sure that when you have your when you draft your representation agreement, you understand who you are representing so that you can avoid any of those kinds of conflicts. And Tim Pierce has a very good article. I don't have it with me today, but he has a very good article about what informed consent means, so that if you do find yourself in a situation where you have a conflict of interest, be sure that you communicate what the potential conflicts are, or actual conflicts might be, so that the client can waive those accordingly. And then with respect to unrepresented persons and dealing with them, when in my life before WILMIC, I worked a pretty active collections practice with Bob Pash, who has written several chapters for State Bar Materials, and literally wrote a book called Wisconsin Collection Law. So I guess I can say he wrote that book on Wisconsin collection law. But when I was there, I got a call from a lawyer who was representing a debtor, and Bob liked to call those lawyers the dark side. But that's Bob. But we talked about the case, the debtor's counsel and I, and we made very reasonable arrangements. There wasn't much dispute about the debt, but there was a desire to pay it over time. Okay, I said, let's figure that out, and we did. And the lawyer on the other end of the phone, he said goodbye, but before he did, he said, you're not at all what I expected from a collections lawyer. You're nice. And I think that one of the things that Bob likes to do is tell jokes, and they're not very good. But this particular one has some truth to it, I guess. And he said, 99% of the collection lawyers give the rest of us a bad name. So I don't think that's true at all. And I think there are plenty of collections lawyers out there that will work well to reach an arrangement for voluntary payments, which is really the goal. But in any event, I think that from a malpractice perspective, be nice. When you're dealing with unrepresented people, or you're dealing with debtor's counsel, I think you will achieve your goals much more easily with a pleasant conversation than you will with in the opposite.
When you talked about informed consent, I would add to that, don't scrimp there. Don't try to do the letter in the shortest possible format. Informed consent, to me, I want to lay out all the options. I want to set forth the pros of this mutual representation and the disadvantages. I want to give a cost-benefit analysis. In fact, I try to do that in every case on every issue with every client. I think that's the way to do things, and I'm a big believer of putting everything in writing. I have already cited to several lawyers, both in my firm out and outside, and I'll cite it to you, Tom's article, I think it's in the May, Wisconsin Lawyer Magazine, about document everything. If there was one thing I could tell you to do to keep your fat out of the fire, it is that. Document everything in writing. There's no other one thing that I think is more important when we're talking about not only malpractice prevention and grievance avoidance, but just good practice.
Why don't we get into some of the things they should know? David, let's talk fees. Who's the client? Who's the opposing party? Those all might sound like fairly simple questions, but I think sometimes they're not so simple. Am I right?
Right, and that's, so now we're going to sort of go through the anatomy of collecting a debt. And it all begins with information. I'm a big fan of a fellow named Sun Tzu. Anybody know who he is? Sun Tzu was a Chinese general, like 4000 BC or something, and there's a book called The Art of War, supposedly written by him, which it's not exactly scintillating reading, but there are lots of great quotes in The Art of War. And one of Sun Tzu's quotes is, "If you know the enemy, you need not fear the result of 100 battles." He's a good-looking guy. I don't know if you can pick that up from here. That's a statue of him. But he's right. It all begins with knowledge. So before we do anything when we're collecting, we want to gather all of our information. That probably starts with your client's file. And what you find in there will vary from, on the whole spectrum, from lots of good information to people that keep next to nothing. But you need to know what's there. What is in there is going to depend, of course, a lot on the type of the debt. A mortgage foreclosure is going to be substantially different from an open balance running account for a dentist or chiropractor. So it's difficult for us to tell you what you're looking for. You're looking for everything. Certainly you have to find the basis for the debt, whether it's a note or a contract or a credit application, whatever that may be. By the way, I'm going to digress for 1 second. As you're looking at your client's file, you can think about more value you can provide and more work you can get for this client. Because when I review my clients' files, I often see lots and lots of things they can do better. Maybe you could help them draft a better contract or a better credit application or a credit application that at the bottom has a personal guarantee so that they have somebody other than a defunct LLC to collect from. So as you're looking at information when you're working on a collection matter, be thinking, I think you should be thinking, about what else you can do. What value-added service can you provide to your client that will enable you to give more and do more for the client. So knowledge is really important. Tom, you mentioned who is the client. That's, of course, important. You have to know, to whom is this money owed? Is it an individual? Is it an LLC? That normally is not as big an issue as who owes the money, who is a defendant. Matt and I have chatted about the fact that we see lawyers that sue something like Bill's Auto Repair. Well, what the heck is Bill's Auto Repair? You might be able to enforce that. It is possible. The Wisconsin Supreme Court has some decisions on this. So depending on the degree of specificity in that name, you might be able to enforce it. But why would you ever look for that problem? You need to know if the person or party you're suing is an LLC or a corporation or a defunct corporation or an individual. You want to know, this is where you want to use your shotgun as well. You want to bring all the parties in that you can bring. So if it is an LLC or some form of limited liability entity, is there any basis for suing individuals? And there might be. One case, I think it's in the materials that is must reading if you're going to do collection work, is the Benjamin Plumbing case. It's in the materials, I don't know the site. But Benjamin Plumbing is about how the owner of a corporation or LLC might lose that limited liability protection if that owner did not disclose that the creditor was dealing with a limited liability entity. So it's a very, very important case. I do a different seminar that is like 40 cases every debt collection attorney needs to know, and it's near the very top of the list.
That one's cited on page 24 of David's outline.
Page 24. So sometimes it's not a long case. You can read it in less than your lunch hour very easily, even while munching. Very important case, but it points out the importance of looking for who you can sue. It is always better to be able to sue, maybe not always, it is almost always better to be able to get a judgment against an individual than against an entity. Because the entities generally seem to end up with no assets and no net worth. The individuals, on the other hand, have a vested interest in protecting themselves, their livelihoods, and their families, so you're more likely to be able to collect. Think about, even if you're suing an individual, do you have a claim against that individual's spouse? Now we start getting into that swamp, murky area called marital property law. But if you're going to be a collections attorney, you have to have a basic understanding about the liabilities that are associated with marital property law. I cannot tell you how many times family lawyers and other lawyers, and certainly clients, tell me or believe that I'm liable for my wife's debt. Well, that's not the law in Wisconsin. You're not liable just because you're a spouse. You may have assets that are available for attachment or liquidation, but it doesn't mean that you're personally liable. So I think an understanding of the marital property law is really important. I can give you a 90-second explanation of it, and that is the incurring spouse, whoever signs the credit application or goes and buys the goods on credit, is personally liable. The spouse is not personally liable unless the obligation falls under the definition of support obligation. And support obligations under our marital property law are really just a codification of Wisconsin common law that existed back when we were a territory and at initial statehood, called the Doctrine of Necessaries. And the Doctrine of Necessaries is fascinating, and we could spend a whole hour on it. We won't, but it's really cool, and if you ever get a chance to read about what is a necessary, it's a lot of fun. A prom dress has been held to be a necessary. I point that out because if you're a collections attorney, you would like your obligation to fall under the Doctrine of Necessaries. You would like your obligation to be a support obligation because then both spouses are liable, and even if they get divorced later, you can collect from either one. If only one spouse is liable, going back to the original explanation here, then you can sue that spouse and get a money judgment. But if those parties later divorce, or the incurring spouse that you've sued and have a money judgment against dies, what do you do? So it's far better to get both spouses on the hook. But the law is that the incurring spouse is liable. You can collect from the incurring spouse's individual property and marital property. So, and that's why people think that the non-incurring spouse is liable, is because you can get a judgment against me and then garnish my wife's wages because they are marital property. But that is a concept that is often confused. I've just given you the quick gloss on it. There, of course, you can get into all kinds of things about tracing rules and things like that. But that gets back to the competence thing again, Tom, is that if you miss suing all the parties you could, that may come back to bite you later when your client sees another lawyer and asks the question, well, why didn't you sue the spouse? And it can come back at you.
Let me just echo a couple of those comments. One, my teenage daughter absolutely agrees that a prom dress is necessary, and she says so. But David's discussion of doctrine of necessaries, there's a good discussion in St. Mary's Hospital Medical Center versus Brody, and that has to do with medical bills and how the doctrine of necessaries applies. If I didn't say it already, that's on page 24 also. But then I did want to circle back to David's mention of when you're looking through the client's file. A couple pages previously, David starts a list of all the things that might be in a client's file. And I want to echo that because I worked for a collection agency for some time, and one of the statutes that we're not necessarily talking about today is the Telephone Consumer Protection Act, but they are intertwined because oftentimes collection agencies or law firms will use what are called automatic dialing and announcing devices, which are very heavily regulated. If you don't know what those are, it's basically a computer software program that can call thousands of people in seconds, which are, those are the robocalls that none of us like. But to be able to call someone's mobile phone using one of those devices, even if you're using it in a manual mode, meaning one call at a time, you have to have express permission from them to do that. And one of the ways you can get express permission is by including in, if you're the original creditor, including in your credit application a paragraph that says, I, the consumer, agree to that, to being contacted by any means, including the use of an automatic dialing and announcing device. So as you're going through your client's file, if you can assist in ways like that, keep that in mind. It's a very, very valuable. David's comment in his outline is that knowledge is power, and he's absolutely right. And so applying that and helping your client is very useful.
Interestingly, Matt mentioned the TCPA, and it's probably beyond the scope of what we're going to talk about today, but the TCPA has only been around for about 10 years. During that 10 years, the growth of lawsuits under the TCPA, if I just pulled out my calculator, you may see me, I wasn't fooling around playing solitaire on my phone. I was trying to do the math. I believe the growth has been 3,500% in that time. In 2007, there were 14 cases, 2008, 16, 2009, 44. Last year, 4,860 TCPA suits started. A similar rise, not quite as great, under the Fair Credit Reporting Act. Again, we talked earlier about how this dissemination of knowledge, the bar is discovering that these laws are out there and people are starting to use them. So the Fair Credit Reporting Act is the one that deals with how do you fix what is your credit score, how do you fix it? Those cases have risen almost triple in the last 10 years. So we're seeing an explosion on this consumer litigation. Now the FDCPA, that we'll probably talk about in some detail here, has pretty much leveled out over the last 5-6 years. But in large measure, that's due, I think, to the fact that credit has sort of leveled out after the recession. It's growing, the debt is growing again now, but we haven't gotten to the point of having all the collections and the violation. So the demographics on some of this stuff are just fascinating when you look at what's out there and what I think we're going to see. So I predict, Tom, that 4 years from now, you will start seeing more claims under things like the TCPA and the FCRA just because of the volume that is starting to grow.
Both of those are more attractive too because the penalties and the damages available under those statutes are stiffer than what's available under the FDCPA. They also have longer statutes of limitation. I believe on the FCRA it's 2 years, and on the Telephone Consumer Protection Act it's 4, whereas under the FDCPA it's only 1 year. So you've got to hurry up to get your FDCPA claim in, but the other ones, maybe you have a little more time on the plaintiff side.
That is one of the good things for lawyers about so many of these consumer statutes where we could have a violation, knowingly or unknowingly, is that they generally have very short statutes of limitations. A lot of them are only 1 year. So it's something, going back to what are we doing when we're starting the lawsuit, is one of the other things I want to know is, are there any counterclaims? Are there any claims that might be asserted against my client under the Wisconsin Consumer Act? Did they violate, did they do something in their, before they hired me, did they violate the law somehow in their collection efforts? And if they did, I want to make sure I understand what the statute of limitations is. And under the WCA, it isn't quite as simple as just 1 year. You actually have to read it because it can be extended. But you want to take a look at that. And not just that, there are other statutes of limitation, or sort of like statutes of limitation, that come into the debt collection practice area. So for example, in the bankruptcy code, if your debtor, if you're a collector and the debtor, you believe the debtor is engaged in a fraudulent transfer, you may want to bring your action, not just your lawsuit, you might even want to bring an involuntary bankruptcy case within 1 year, because during that 1 year, the debtor might be denied a discharge. Maybe you don't even want to bring it. Maybe you just want to call and point out that I'm going to file an involuntary bankruptcy unless my client gets paid. Another and much more typical limitations period to think about are preferences. A preference is a unique animal to the bankruptcy code and to Chapter 128 under our Wisconsin receivership laws. They're a little bit different, but they're in theory they're the same. In concept, they're the same. And that is that if a debtor pays you and then files a bankruptcy or goes into a receivership, we're going to take the money away and throw it in the kitty for all creditors to share, so that debtors or creditors can't force a preference of a single creditor or two to eating up the debtor's assets. So they can be voluntary, they can be consensual by the debtor, or they could be involuntary. For example, garnishing the debtor's wages can be a preference. So the time limits under the bankruptcy code is generally 90 days. So one of the little tricks to keep in mind when you're collecting is, if you believe the debtor might be considering a bankruptcy, maybe you don't want to be real aggressive for 90 days. Maybe you want, I see Lisa Leitz chuckling because I know she does this. Maybe you want to get your judgment and docket it, but not garnish right away. Now, I know that's anathema to collection lawyers. Oh, I'm not going full bore ahead. But sometimes it might be prudent to wait the 90 days so that your judgment lien is not a preference. Just something to keep in mind. So you got to be aware of all these little things that are going underneath the surface when we're doing this. I forgot where we were at.
May I ask a question?
Yes.
Yeah, go ahead, Bill.
The circumstance of a judgment lien not being wiped out in a bankruptcy anyway, how does it work out?
Well, the question is, what are the circumstances of a judgment lien not being wiped out in a bankruptcy? Great question, Bill. Judgment liens under Wisconsin law, and our state is fairly unique. So if a debtor goes through a bankruptcy and obtains a discharge, under our law, the debtor, after they get the discharge, can file a very simple application in the state circuit court and get a satisfaction of that judgment. At one time, we didn't know that that's how it worked. I can remember back when we as practitioners thought that would only apply to exempt property, like a homestead. But there's a Wisconsin case, I don't think it's in the materials, it's called Megal, M-E-G-A-L Development, probably from about 12 years ago. And in Megal, the Wisconsin Supreme Court said, no, this judgment satisfaction procedure applies to all judgments. So you're right, but it's still valuable to have a judgment, because imagine that there are some assets in the bankruptcy, and there sometimes are, and therefore you might get paid because you're a lien holder, and especially if the bankruptcy were a reorganization, an 11, 12, or 13, we may have to treat your claim as secured as opposed to unsecured. and it's always better to be secured, almost always. I should never use the word always. Almost always better to be secured than unsecured. Another thing that happens with judgments, bankruptcy trustees have learned about Magle development, and they know what we bankruptcy lawyers do after a discharge. So sometimes they will come to the judgment creditor, your client, and say, look, I know you got this judgment, you're going to get wiped out. Why don't you assign it to me as the trustee and let me liquidate this property, and you will get a share of that. So I've seen that happen too. There's not one rule fits all here, but I am cautioning you to always be considering what the debtor might do. Sure.
So if you docket the judgment less than 90 days before the bankruptcy, then it is considered the preference if it's over $600 for consumer debts and would automatically be wiped out compared with the scenarios you just went through?
The question is, if you docket the judgment and the debtor files a bankruptcy within 90 days, is that judgment lien going to be wiped out? As a preference. And the answer is maybe. And now we get into the definition of a preference. And a preference is a transfer, which is very broad. It would include the granting of a lien, even a non-consensual judgment lien, to or for the benefit of a creditor, your client, an interest of property in the debtor, which would be you getting a lien on the property, made while the debtor was insolvent, made within 90 days, unless it's an insider, I won't go into that, of the bankruptcy filing, that enables your client to fare better than he would have if the lien had not been granted and their Chapter 7 was filed. That's the part that sometimes gets confusing to people. So it would be a preference if there was something that your lien attached to that had value. Now, if you just were a fourth judgment lien on a piece of property that's already over-encumbered, it's probably not a preference. But it could be. But generally, unless there's some reason, like I said, that it's impacting an asset, the debtor isn't going to bother bringing a preference action. It's cheaper for us to avoid it afterwards. But yes, it could be a preference. The main preference that collection attorneys run into is losing what's been garnished. That happens all the time. A good, I don't want to say majority of the cases we file, but a plurality, probably a very substantial percentage, are situations where someone's been garnished, and then after we file the bankruptcy, you get a letter from us saying, hey, return this money, it's within 90 days. Now, as a collections lawyer, trick, you don't have to do that. Just because I asked for it doesn't mean you have to send it. I actually have to bring the preference action. I shouldn't be telling you this because it's going to be more costly for my clients. But you don't. There's nothing in the law that says that because you received a preference, you have to return it. You don't have to return it until there's a court order saying you have to return it. So maybe you could cut a deal with me and you could say, Krekeler, I don't want to return this. It's going to cost you money. How about I keep $300 of it and you take the other $600? Something like that. So there are always options. You know, I'm a big believer that there is nothing that cannot be negotiated.
Any other questions at the moment? Z.
Yeah, I wanted to bring up the EFTA, Electronic Funds Transfer Act. It's another growing area that collection attorneys need to watch out for. I see that a lot with the payday lenders and automatic payments.
Yeah, there is no shortage of what I call the alphabet statutes that impact collection law and debtor-creditor law. Besides EFTA, we have RESPA, Real Estate Settlement Procedures Act, which we don't see as much of now, but if you went back to 2010, we were bringing RESPA actions then because there were so many foreclosures going on. You have TILA, TILA, Truth in Lending Act. That's on the auto loan or the appliance purchase where the 5 boxes across the top. You've all seen them. That's Truth in Lending. There's CROA, Credit Repair Organization Act. We could probably think of a few more if we put our minds to it. So there are lots and lots of alphabet acronyms out there when it comes to debt collection law. And I'm no expert on all of these. In fact, I do not know a Wisconsin lawyer who's an expert on all these. The volume of the law, not the statutes, they're enough, but the regulations that go with these is so voluminous. Z, do you know anybody who's an expert on all those?
I'd say Mary Fonz is as close as it gets.
Yeah, there just isn't anybody that knows all this stuff. So if you want to create a niche practice for yourself, learn everything there is to know about CROA, Credit Repair Organization Act. And I point that one out because the Fair Credit Reporting Act is closely in line with that. Wisconsin has a statute on credit repair. It's called, I'm trying to think of what they call it, Credit Services. Email me and I'll tell it to you. But CROA deals with people who are charging your clients to repair their credit reports. You've seen ads for this, right? We all have. They're very strict about what they have to do, both under federal law and our version of that law. But very few lawyers probably even know it exists, and fewer still have any kind of an understanding about it.
I think that highlights the reasons why we say don't dabble if you don't know these laws, and many of us don't. Don't practice there. You're going to run afoul of them, or take the time to learn them before you step into the ring, so to speak.
In terms of the alphabet laws, we're going to get into FDCPA here in a second, but before we do, David, as we go through this anatomy of a collection action, what about getting client documents, the right ones? What do you need to get? What are you looking for? I know you've touched a little bit on this.
It's going to depend on the type of the case. So you certainly, no matter what kind of lawsuit we as lawyers ever bring, the first thing we have to do is identify our elements. I do the same thing in bankruptcy. If I'm bringing a motion, I got to know what are the elements I'm going to have to prove. What is my prima facie case? And that's what the first thing you have to get from your client. But it's the little added information that might really help. So, for example, when a new client comes into me, if they pay by check, I always keep a copy of the check. If I ever have to collect from them, which I won't, then at least I know where they banked at one time. So it's a good practice for you to teach your clients. And again, this is a marketing opportunity for you. You can now go back to your clients and say, you know, we ought to do an audit for these things. One of the things I've done with some of my clients over the years is I've taught them to bring their own collection cases and small claims. So I spend one time with them, or over a month, maybe 2 or 3 meetings, teach them how to do it. And then they can do it themselves, because a lot of times they can't afford to pay us to bring small actions. But you can be extremely valuable by teaching them these things, and that goes for what should be in their file, Tom. So credit applications are really good. It's good to know where people bank. Trade references, maybe. I don't find them that valuable. Sources of income are valuable. Tax returns are really, there's a wealth of information. We could do an hour on what you can learn from a tax return, the little tricks out of that. So it's nice to get that. A good credit application that you can help them design is exceedingly important. But then there are other things you want to ask for. Has your debtor ever complained? Are there any letters? Just as important as a complaint is the note or email where the debtor thanks you for what you've done for them. This applies to lawyers too. If a client thanks me, I always save it. I save everything. There's nothing that I don't save into our system. Good, bad, ugly, it all goes in there. But imagine how helpful it is if you can find a note or a letter from the client, or even a contemporaneously taken telephone note that your client even took, where the debtor thanked them for whatever it is. You know, I got my new car, and boy, this is great. I just love it. And then later they're complaining about some service that happened before that. So those are really valuable. You have to be thinking constantly about counterclaims. Back to my buddy, Sun Tzu. Remember him? This guy's fantastic. He should be practicing. He should be teaching law practice management.
Yeah, but he lived 4,000 years ago, right?
You know, we could do a whole seminar. We could easily do an hour on Sun Tzu on the law.
All right.
So
Let me write that down.
So Sun Tzu says, "He will win who knows when to fight and when not to fight." That was my little Chinese accent in there. But the point is, sometimes it's better not to sue. If you aren't going to be able to prove your case, everything you need, or if it really isn't enough money to justify what might come out of it, and we're going to talk about that with the FDCPA, or if there is a counterclaim. You know, one of the things Matt and Tom will tell you about you suing for your fees is if you're going to do it, you have to have all the things I just said, and then you also better make sure that you've thought about, is your client going to file a counterclaim, and what is that going to cost you? Because I think we even have a couple of examples in the materials where lawyers, we're like everybody else. We get irate. We expect fairness, and sometimes people don't treat us fairly, and they don't want to pay us for the good work we do for whatever reason it may be. But before you run off and sue, you got to think about what might the cost be to me. Because if a counterclaim comes and you're at depositions instead of billing your time, and your WILMIC deductible is $10,000, do you really want to sue for a $2,000 debt? You got to think about that, because remember, I don't know this fact, but you will, the percentage of when we sue for fees, how often it results in a counterclaim, and no matter how bogus that counterclaim is, it's going to cost you. So I don't know if you have that statistic.
Well, for many years it was running somewhere in the neighborhood of a third of our claims, and I know the ABA has measured that nationally as well, and their number was even higher. So there's no question that's out there. I mean, it happens.
We do field that question quite often. What does WILMIC think about suing for fees? And I'm a lawyer. I get it. I've been in that situation. I have sued for fees. And I think our job as the carrier, I think, is to educate you about the risks, which is exactly what David is doing right now. And it is out there, and it is real, and it is something that's measurable and has an impact. Get what you're owed, but be reasonable, because suddenly you're paying your deductible or more if it's a successful counterclaim, and it is a real risk.
And it's a personal preference, I think. I've written several columns in the magazine about this topic, and I've talked to a lot of lawyers about it for those columns. Some lawyers will tell me, under no circumstances will I sue for fees. I don't think it's worth it. It becomes more of a headache. And then other lawyers say, I deserve to get paid, and so when I think it's necessary, I'm going to sue. We had an insured many, many years ago who sued clients for fees 76 times over a 5-year period. Needless to say, me and our underwriter paid him a visit to talk about that as to why that was happening. What are the underlying reasons for it? You got to drill down a little bit. It's more than just a financial issue at that point. It's why are your clients not paying you? It's important, at least it was certainly for that particular lawyer, to look at procedures and communications methods with clients and all those sorts of things, because there are many different reasons why clients don't pay. Maybe they can't afford it, or maybe they run into financial trouble, or maybe they're just so unhappy with their representation. I mean, there are any number of reasons, any number of messages that they're sending you as to why they're not paying. So there are a lot of layers to that onion for sure, but it's something to really keep in mind when you're talking about fees and whether to sue.
I just wrote that down. Why? And I'm not using customer or clients. I'm going to use customers. I just thought of another way you can add value to your clients. We are not just litigators. We're counselors. So maybe the question you ask of your client is, why are your customers not paying? And with our wide experience as lawyers, maybe we can help them identify that and avoid some of their accounts receivable problem, and think what a hero you'll be to your client then. But going back to the collection aspect, you have to know if this is going to be worth it. Is there, one of the things you have to know is there any possible risk? So I always ask my client, is there any complaint? Is there anything that they might say, no matter how foolish or ridiculous you think it is there anything they might say that they have a claim against us for? Is there anything they might be unhappy with? Because I think that's really valuable to know before we go ahead.
Yeah. Looks like we have about 20 minutes left in this session, and so we're going to move on in the alphabet laws. FDCPA, Federal Fair Debt Collection Practices Act.
Tom, can I, two other things?
Yes.
Two quick comments about the lawsuit.
Go ahead.
The two things that I would caution you about when you're bringing a lawsuit, especially a consumer debt collection suit. One is venue. I won't cover it because we don't have the time, but it's not difficult. But you have to know that venue in a case that you bring is going to be governed by the FDCPA. And the FDCPA has very strict venue provisions. They are not jurisdictional. Similar but slightly different under the Wisconsin Consumer Act, which will also govern any suit that you bring. There are specific venue provisions, and they're slightly different. They're in the materials, I think page 26. So don't run afoul of that. Especially under the WCA, a venue violation is jurisdictional, and there's a couple of cases companion cases cited in the materials. It's the Kett v. Johnson cases. Again, lunchtime reading. They're also on my list of the cases you have to know, because if the court lacks jurisdiction and enters a judgment and you attempt to collect on that judgment, you have now violated, now you're going to have multiple violations of the FDCPA and the WCA because you're attempting to enforce a right you don't have. The second error that I see, even more often than venue, is service of process. I would venture, I've never actually kept a log, but I would say between 25 and 33% of the lawsuits my clients bring to me to defend, service was improper. I know that when you're doing collection work, usually it's not going to come up, because the average layperson, most collection work, there is no opposing attorney, and it's not caught. But you need to be aware of, it isn't so much you need to be aware of it. I know you know what the service rules are, that it has to be personal service, and you can only do substitute service after exercise of reasonable diligence. And we all know reasonable diligence isn't exactly defined anywhere. But there's a case in the materials, I think it's Austin v. Heaston, that I would commend to you to read. It's also on my list. But direct your process server, whether you're dealing with a sheriff's deputy or a private process server. I prefer private because they'll do what I want. The sheriff may do what he wants. Tell them how many times you want them to attempt service before they use substitute service. Because if they just go out there and the first day they give it to somebody, that probably isn't going to work. And you're falling right into my hands when you do that. I'm either going to bring a motion early for some strategic reason, or I'm going to wait until right before you get your judgment, or maybe I'll even wait until after you have a judgment and see if you do something wrong, because like venue under the Consumer Act, jurisdiction is jurisdictional, and it is always jurisdictional. If you don't have proper service, the court does not have jurisdiction over the party, and that means anything you get is void. And imagine trying to explain that, if for no other reason than having to explain to your client 2 years later why their judgment is now no good. That alone is, I live by embarrassment. I'd rather avoid embarrassment than lose money. So for me, I would never want to have that conversation with my client. Oops, I guess I didn't get him served right 2 years ago. So that sort of leads into the FDCPA, Tom, because these venue rules are governed by the WCA and the FDCPA.
Yep. And we'll turn to Matt for a little more on FDCPA. Question, Katya?
Yeah, did you get to the question about the court costs for adversary proceedings?
I did not get that on my mobile device.
Before you move on,
Okay.
The question is, if the creditor doesn't voluntarily pay preference, won't the creditor have to pay court costs for an adversary proceeding?
That's a good question. I don't think I've ever seen it happen.
So maybe, but probably not.
Maybe, but probably not. I've never seen it happen. I will check and I will I'll put the answer in my newsletter and on my blog, so you don't have to get my newsletter. My newsletter is free. If anybody wants it, just give me your business card. Those of you out there, email me. I'll send it to you. I'll answer that question in my newsletter and my blog within the next 30 days because I don't really know the answer.
Thanks, Katya. It appears they're not coming on my device, so I'll keep an eye on you, and we'll go from there for internet questions.
Well, for court costs, I don't think the debtor's attorney has to pay a filing fee for the adversary proceedings. It's probably just whether the creditor's attorney, the creditor is going to be able to have to pay attorney's fees. There won't be any real court costs.
And there shouldn't be any attorney fees awarded unless there was some kind of a violation, contempt, which normally wouldn't happen in a preference recovery. Which is why I mentioned to Bill with his question about the preference that maybe I'll negotiate because I cannot recover attorney fees. The debtor's lawyer, barring some unusual circumstance, cannot recover attorney fees in a preference action.
Okay. Matt.
So what is the FDCPA and why are we talking about it? So in 1977 or 1978, faced with an abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors, Congress passed the FDCPA. So I don't think there are people who show up on doors with baseball bats anymore, although there might be. But in any event, let's put the brakes on what we allow debt collectors to do, and let's, through the Fair Debt Collection Practices Act, regulate some of that activity. David, chime in any time, but I think the best place to start talking about it, and we've hit on a lot of it already, is are the definitions in the Act. First is communication. How do you, as the debt collector, communicate with the debtor? And it's a very broad definition, as most of the definitions are in the FDCPA. Communication means the conveying of information regarding a debt directly or indirectly to any person through any medium. So I don't think when the FDCPA was written they had text messages in mind. That just didn't exist. It does now. Certainly if you are going to communicate in any way, including a text message or an email, you need to be aware of what you must say and what you cannot say in those communications. You also need to be aware of, specifically aware of who you are communicating with. If you have a generic email address, you don't really have a guarantee that that isn't going to be seen by a third party. The FDCPA also regulates communications as far as disclosing the nature of a debt or even the existence of a debt to a third party. So if that email is a home email, I have a general email, Beier at whatever.net, my whole family can see that. And if we're talking about a debt that shouldn't be seen by a third party but can be, you face a violation of the FDCPA. And it is a strict liability statute. You're on the hook if that violation can be proven. So be aware of how you communicate. Courts don't really feel sorry for you as a debt collector because there are so many means of communication. A letter is probably the safest bet. We don't have to dispute about what was said. It's read the letter. And if the letter is a violation, so be it. But at least you change your letter. But at least we have something to look at and to read to know exactly what was said. Phone calls too. We mentioned the Telephone Consumer Protection Act. What happens with messages these days? The voicemail that's left on a phone to which a third party might have access, and did they hear it? There are all kinds of horror stories about people who get messages from debt collectors by telephone. There's a case out there called FOTI, F-O-T-I. I'm sorry, I don't have the I don't believe I have the site. If I find it, I'll tell it to you.
I think it's a California case.
California case, and it talks about what must be disclosed by a debt collector in a phone call and or a message. And if you don't give a meaningful disclosure of who you are when you call, you've just run afoul of the FDCPA. So the best advice, is don't leave messages, voicemail or otherwise, through the use of a phone, because you don't have a guarantee about who can hear it. Unless you actually speak with the debtor and you have express permission to leave a message on the number that you are calling, don't do it. Do you disagree with that, David, or do you
No,
fully
I agree.
agree with that?
One of the problems with this law is that technology has totally outstripped it. We didn't have voice messages in 1978, and certainly we didn't have texting. I would never text with a debtor. I don't even know if you have enough characters to put in all the disclosures. I don't think you do. So I wouldn't do that. I think your advice is right. It may seem antiquated, but probably a letter, an email is probably okay because you can get the disclosures in there. But I certainly would never text, and everything we're going to talk about on this last section, always err on the side of caution. You cannot go wrong doing exactly what the statute says from a collector's point of view.
I agree. We do have the question, did Congress categorically exclude all pleadings? We're lawyers. We exercise, we practice law. We file pleadings, and I think the answer to that has been definitive no. The pleadings are in fact communications, and I don't have the site. Do you, David? But in any event, treat your pleadings as a communication with the debtor. And so all of those things that need to be in a communication with a debtor, whether it be a letter or a pleading, those communications need to appear in both. One of those communications, or one of the things that a debt collector must say, is what's been commonly referred to as the mini Miranda. This communication is from a debt collector. It's an attempt to collect a debt. Any information obtained will be used for that purpose. When you are dealing with consumers, that should appear at every single writing, every single piece of paper that ends up in front of the debtor should have that mini Miranda on it. So be aware of that. That's one of the requirements of the FDCPA. I think I'll move to a different definition, and that is the definition of creditor. Creditor is defined as any person who offers or extends credit creating a debt or to whom a debt is owed. A creditor is not, a creditor's actions to collect a debt are not governed by the FDCPA. So be aware of the distinction between a creditor and a debt collector. As a third party trying to collect a debt, you are governed by the FDCPA. If you are the original creditor trying to collect your own debt, then you are not governed by the FDCPA. There's a difference between the FDCPA and the Wisconsin Consumer Act. The Wisconsin Consumer Act will govern anybody's actions in the attempt to collect any debt, if it's a consumer debt. And then who is a consumer? A consumer is any natural person obligated or allegedly obligated to pay any debt.
Matt, you want to touch on trap and garnishment? I think you guys wanted to do that under the FDCPA.
One comment about the collecting debts. The U.S. Supreme Court just issued a decision. It was new Justice Gorsuch's first opinion was an FDCPA case. And that decision is, I don't have the site, but it's on page 4. It's the Henson v. Santander case. And in that case, they held that the FDCPA does not apply to debt buyers. And that's a growth industry, as you probably are aware. If I said names like Portfolio Recovery and LVNV with all the Roman numerals after it, and I mean, the list goes on and on about who are debt buyers. When I started doing this work around 1990, there was no debt buying industry, and now it's huge. But the FDCPA, really important, Matt touched on how the creditor may not be subject to the FDCPA. And originally, lawyers were not. But the very first amendment to the FDCPA, about 3 or 4 years later, brought us in. So when we are collecting a consumer debt, we are subject to the FDCPA, which is why it's so vitally important for us as debt collection lawyers.
That discussion is also on page 4, and there's it does talk about whether attorneys regularly collect debts. And there isn't perfect guidance there, but there is one case that held, an attorney who averaged less than 2 collection matters per year over 10 years, and it was less than 1% of his practice was held not to have been subject to the FDCPA. So maybe if you dabbled just a little bit.
It does not. All right, so here's the first disagreement of the day. I say comply with it every time, because if it is alleged that you were a debt collector or subject to the act, the cost to you is going to far outstrip the cost of complying. Compliance with this law is not difficult, except when you get into things that are weird, like, what do I do with a voice message? But otherwise,
Second
compliance with the
disagreement.
law is pretty easy.
I think compliance with the law is seemingly easy, but you can run afoul of it just as easily.
Especially if you don't think you're subject to it.
Right. And so I was joking, and I changed my mind. I agree with you now. I think you should assume you are a debt collector if you are collecting a consumer debt. And the more important determination to make is whether or not the debt is actually a consumer debt. Which, David, maybe you can comment on this. There was a case about a backhoe in your materials where the person used or rented the backhoe through his business, but he used it to build his home. So seemingly a business debt was in fact a consumer debt because of the purpose for which the backhoe was used. Did I get that right?
And yes, you did. And there's case law out there on these weird cases like that. And if it was a consumer debt when I took out the loan, but now it's not. So I used to live in this house and now I rent it. Is that subject to it? So we could go on and do a lot of research. Why would you ever do that? Why don't you just comply with the act? The act has 2 components to it, which is why I say I think it's relatively easy to do. The act does 2 things. It restricts and governs communication. How do you communicate with the debtor and how do you communicate with third parties? And then it has prohibited practices. And the prohibited practices, there might be a few little tricks like dealing with post-dated checks, but generally, if you follow what Matt said earlier, and you are the nice lawyer, you act reasonably, treat the debtor, the debtor's counsel like you would your own family. You don't let your kids get away with murder, but you don't lie to them and harass them and abuse them, probably. So those are the 2 components to the act. It deals with communications, which sometimes it says specific things you have to do. The validation notice, there's 5 specific items that have to be disclosed to the debtor. And then there's the mini Miranda on every communication. You got to say this is from a debt collector. That's pretty easy to do. And then you have the conduct. And frankly, just being a reasonable person, as I look out in this room, I don't see anybody here that's going to violate any of the conduct rules. So it isn't that hard to do. Where people get in trouble, the vast majority of these cases, people get in trouble because they think they can do it better. So I don't want to tell, I'm going to lay this out for the debtor. I'm going to tell them the amount of the debt, but I'm going to throw in some other stuff. I want to charge them for interest or attorney fees or whatever. And by the way, that's really important, and I should have mentioned that earlier. When we're talking about what are we doing, attorney fees and interest, don't attempt to collect them unless you're entitled to them. Be sure you've checked and made sure that you're entitled to them, because that is a spot where it's real easy to have it's a real easy violation to prove if you weren't entitled to it.
Gentlemen, we're almost out of time. Any questions from the audience here? Yes, sir. We'll get him on the microphone, make sure the internet people can hear you.
Hi, could you make just comment briefly on coverage under WILMIC with violations of the Fair Debt Collection Practices Act, because your client doesn't have a malpractice claim against you. You're violating the act. You're the sinner, and you're the one that's going to be punished. So how does that play into coverage from WILMIC for malpractice?
I think the best way I can answer that is to say that it's sort of a backdoor to coverage, meaning your client, the original creditor, is relying on you to collect the debt and your provision of professional services to do so. And you're not wrong. When the claim then is brought against you alone as the debt collector, where is the malpractice? I get that and I understand it. And from a practical perspective, we assume that next step, which is that the malpractice occurred when the professional services provided to the original creditor ran afoul of that law. Okay, that doesn't mean that we cover every aspect of it. There are specific portions of the damages in the FDCPA that might be excluded in WILMIC's policy. That isn't always the case. But it is a question worth asking. And I hope I gave you enough of an answer.
And oftentimes, an FDCPA claim is going to be joined with a WCA claim against your client. Personally, I don't like bringing claims against lawyers, but I have very little reason not to bring claims against your client, which I can usually do. Chapter 420, we didn't have time to get into the WCA. Almost all of it, what we would be talking about, is in Chapter 427. It is only 1 page long, so it's real easy for you to look and see. But what you'll see is that it pretty much is a mirror of the FDCPA. It's just a condensed version. So a lot of times the FDCPA violation will be joined with a WCA violation against your client. So now you do have the malpractice claim. The other thing that often happens is if I'm bringing an FDCPA claim, what I want as part of the deal is that my client gets off the hook on the debt, which means you have to go talk to your client about how this is going to get handled.
Before we wrap up, it sounds to me, what I've been hearing from you guys is this is a very deadline-driven area of practice. Am I right? And if there's any takeaway here, is it?
Bankruptcy is a very short deadlines and lots of them. FDCPA is very statutory. The statutory restrictions are laid out. Follow them to the letter. Don't try to change anything.
And one final note, the court doesn't always give you very much help, but there are 2 cases out there worth reading. Bartlett v. Heibel, it's in the materials, and then Miller v. McCullough on page 11. They offer safe harbor language to include in your letters under certain circumstances. When you have the ability to use a letter that the court approves, even if there may be some minor violations that the court didn't even see in offering that language, use it anyway, because it will benefit you in the future.
All right. And no other questions that I see from the internet. So Katya's going to do a quick check here. Nothing else coming in? Okay, good. So we'll take a break, about 15 minutes for those of you on the internet. We'll be back at 10:30, and we will take up the issue of estate planning. I want to thank David Krekeler and Matt Beier. Please give them a round of applause. They were terrific. We'll be back at 10:30. All right, we're back. We will now take up the issue of estate planning. And once again, my name is Tom Watson with Wisconsin Lawyers Mutual Insurance Company. I will be moderating this session as well. And like bankruptcy, there are a lot of minefields and pitfalls in estate planning that we will get to. My panelists for this particular session include to my immediate right Brian Anderson. Brian is Senior Claims Attorney at Wisconsin Lawyers Mutual. Brian has been with WILMIC since 2003. Prior to that, he was in private practice, focusing mainly on personal injury work. And Brian is also a former football player at the University of Wisconsin. Looking forward to another season, I'm sure. Brian, are you not? It does feel like fall. It does feel like a football day, doesn't it? Yep. All right. And to Brian's immediate right is Bill Williams. Bill is a shareholder in the law firm of Bell, Moore, and Richter in Madison. His practice focuses on probate and estate planning. He represents businesses of all kinds. And Bill is what I would consider to be an estate planning expert and someone we rely on to get much of our expertise and information on estate planning. So let's get right into it. Like bankruptcy, we started talking about the fact that bankruptcy had moved up on our list of claims. This area of practice is no different, right, Brian? Estate planning is the last couple of years has moved up.
Yeah, we would be number one, but for bankruptcy and collection. So Bill and I got relegated to the second half because estate probate trust is number two and has been since at least 2015. In fact, I have the stats running all the way through the end of July of 17. And estate probate trust is what we do. This is the most, and Bill asked the question, but we're talking about frequency of claims, not necessarily the payout. And hopefully programs like this will help. You may get a claim, but if you don't pay out, that's good because you have a well-documented file. But in 15, estate trust probate was number two. In the year 2016, it was number two, and thus far in 17, number two, representing those years about 20% of all claims that WILMIC gets, and we track 30-some areas of the law. So that's way disparate as far as the number of claims in that area. So it's a high-risk area, which makes this program. Tom, you put in a great program. You had the number 1 and 2 areas of claim. I don't know how you came up with that, but
Funny how that works.
Yeah, and it just continues. I'm a little bit surprised, although that was Matt and Dave's program, that bankruptcy and collection has stayed there. We were thinking that when the economy got going, we wouldn't see as many claims. We thought that was going to be driven by the Great Recession, but it's continued as number one. But I think estate probate trust is here to stay as far as claims because of the amount of wealth being transferred and family dynamics are changing. Bill will get into that in a lot longer in the program, but it's just an area that there are going to be people unhappy, and one of the sources that easier to blame mom, dad, or brother is to blame the attorney that you never met, which is another unique thing about estate probate trust claims. You think, well, my client's dead, I'm good. It's the beneficiaries that bring the claims, and it's a weird area because normally you do need privity to bring a legal malpractice claim, but estate trust probate, you do have an exception when you're a disinherited beneficiary. At least you believe that's the case. So anyway, that's we're number two. We're working on trying to get up to number one. The rankings are always important. It's one of those adverse things, but.
You're used to looking at the top 10 football rankings. I don't think you're not trying to get to number one. Well, let's start at the beginning. I guess, I don't know of a better place to start than the engagement letter. Bill, maybe we can start there and you can tell us, documenting who your client is and all that kind of stuff. That can get tricky in estate planning as well. Am I right?
Sure. And one thing about estate planning is that most of the people that we do estate planning for think they have simple estates that shouldn't take very long to prepare a plan for. So why don't you just knock this off during your spare time? You're just going to pull a form off and fill in the blanks for me anyway, right? So why bother with all this? Well, if you've done any estate planning, you know that's almost invariably not true. In fact, I'm still waiting for my first simple estate to come through the door, and I've been in practice since 1985. But Another thing you'll run into is, well, why do we need an engagement letter? Because you're going to do this, I'm going to pay you, and we'll be done in no time. Your response has got to be that it's probably required, and second, it's the best risk management thing you can do. If the fees and expenses involved could amount to $1,000, then you're required to have a letter. Even if it's possible you're going to get under that, you should still have a letter, because it is your best chance to document who your client is. And remember, you've got to build a file for yourself that you can rely on maybe 20 years down the road when this is the greatest euphemism of all, when your estate plan matures and people are starting to ask questions about why Dad wrote it this way, and it's really your fault, isn't it, that I didn't get all of the stuff.
One thing on that note, I don't know if this was mentioned in the first program, but Wisconsin legal malpractice is that you're in the worst state to practice. It's a 6-year statute, but the discovery rule applies, so that Bill's point, and I know Dave or Matt were talking about some shortened period with FDCPA. You don't have that benefit with estate planning. So you're going to get the claim potentially 20 plus years that when someone dies,
Sure.
Which we'll get into file storage and retention and why this is, and Bill keeps every file he's ever worked on. I know that. So
To the dismay of our office manager. But the other things you can do in this letter are carefully define the scope of your representation, because it's very important that you and your client understand what you are, and more importantly, are not doing for them. The other sort of housekeeping things that you want to define, how you're going to communicate with the client, which email address. This is a nice one to get knocked out right away. A lot of people will email you at work, but they don't want their estate planning documents emailed to their work email address. So just ask them, what email address, if any, should I use for this? Are you okay with email? Your letter is where you deal with conflicts if you've got them, and we'll talk more about that, but you've got a conflict situation anytime you represent a married couple, just because this is a community property state, and the letter is the best way to deal with that. And likewise, this is where you stake out your ground, that how you're going to handle confidential information between spouses. You don't want to be in a situation where after a meeting, one spouse, and this has happened, comes to you and says, I have a child by a prior relationship and I want to take care of them in my will, but I don't want my spouse to know about it. You have a huge ethical problem right there. So how do you deal with that? I mean, you can't control people's lives, but you can tell them on the front end, anything that either of you says to me is not confidential with respect to the other. So among the three of us, there are no secrets. That may end the representation under certain circumstances, but you're in a much better place. The engagement letter is also a good place to ask the magic questions that we'll talk about later, that you need to ask about what people have, how they hold it, and what do they think it's worth. So even if it's a simple plan, get an engagement letter in place.
And the letter can be used to identify the client, right?
Yes.
Which is important.
Yes, and it seems obvious to the client, but think of it this way. You are not only confirming with the client that I am representing you, I am not representing your children, even the one that does everything for you and who called me and asked to set up this meeting. That letter then documents, not just to your client, but to everybody else, who your client is and who your client isn't.
Bill, do you get clients come to your office and they show up with the kids in tow, or the
Oh, sure.
Yeah. And so what do you tell them?
Well, it kind of depends on the circumstances. I mean, if it's their 4-year-old, we try to hand them a pad and ask that they not write on our carpet. But it's more and more common as you're dealing with older clients that they will show up with the adult child who is their primary care provider. And often those people aren't content to sit in the waiting room while you meet with their client. They want to help because, dad doesn't hear so well, or mom, sometimes gets a little confused, and I want to help this along. And you've got to be very careful there because often the next shoe to drop in that situation is, since I'm the only one that takes care of Dad, he's going to leave everything to me, and my 3 siblings aren't going to get anything. There's no problem there, right? That's when you've got to be very careful. And there are things you can do and that you should be doing to protect not just yourself but your client from capacity and undue influence claims against their estate plan. And one of those is documentation. Another is you make sure that at critical points in the process, and it might only be once, but it probably shouldn't be right before they sign the document, you're alone with that client. And you're asking, is this really what you want to do? And you can tell me, because I'm not telling anyone else, do you really intend to take your pick? Give the house to your son, give everything you've got to one of your kids to the exclusion of the other. You need to satisfy yourself that there's not undue influence going on. And you need, I think, to competently represent your client, to try to build a file where you write a memo that says, I met with this client on this day, and they seemed oriented, and I talked about these things, and yes, indeed, they want to favor one child over the other, and they told me that these were the reasons why. And that's good malpractice defense. It's also good lawyering for your client.
Well, a quick question, Bill, on that, because we have a claim that we talked about this in preparation, but you're making a call on a client that maybe you're meeting with for a half hour, hour or two, as far as competency. Do you do anything in terms of records, medical records, or anything further that would at least
It depends
verify
on the
your
situation.
decision?
Oh, on whether the client's got
Yeah.
capacity? Well, and as we've talked about, competency is a minute-by-minute thing, and all you need is the magic lucid interval. They just have to be oriented, know kind of roughly what they've got, who the likely objects of their bounty are, and be able to coordinate those things at the time they're actually signing the document. I haven't sent people off for medical evaluation. In close cases, that might really be appropriate, but I haven't gotten to that point yet, or I've recommended that. And I kind of question the utility, because if they're good on Tuesday, that doesn't mean they're good on Thursday. So, and let me just bring this up quickly. Another thing that we've talked about is whether everybody should be videotaping will signings. Yeah. I've come out on the side of not doing that, because, what if it's a bad day and you've got the videotape rolling? What do? Destroy it? Boy, that's going to make a great record. And what you can do in that situation is, okay, maybe, they missed their meds, or they didn't eat, or they didn't sleep well, so today's not the day. You could try again in a week and it might work. I mean, if you keep having repetitive problems, you've got a bigger issue. But documenting for posterity your client's bad day, to me, seems like not a good idea. But I'm sure others might feel differently.
I'm glad my bad days aren't on tape. They're hard enough to live with in my memory.
That's right.
So, Bill, when I'm looking at the claims that we see, you have this situation where you have a previous client or a referral, normal distribution. Those are kind of easy. But then there's this ratcheted thing that family discord, like check 1,
Yeah.
unusual distribution, risk number 2, urgency of either the health or condition of the client and or the beneficiary being real urgent. Who's calling the shots? It comes down to, do you treat those differently? How can you protect yourself and the client when you have these other variables there?
I think that it's a matter of intake's your best shot to deal with that, because there are some situations where your right decision, and this is always the easy answer, and I'm sure your carrier thinks this is a great idea, or you just say, no thanks, I'm just not going to do this representation. And often, one of the first things you'll hear out of somebody after this case is over is, I wish I had never done this. The fee I got was never worth it. So keep all that in mind, and the thing about 10% of your clients causing 90% of your problems. So you got to have your feelers up on the intake. Does this sound good? I am very wary when the person who calls me is not the person who's going to be doing the estate planning, because right away, to me, that's almost a presumption of something's going on, especially if I hear that my client's elderly or has other cognitive issues. So you got to look at it at that stage. And then I think you've just got to keep your feelers up the whole way. You know, and then as you go on, you find out, well, we're disinheriting so-and-so because they're a bum. Well, okay, that's absolutely the client's right. But you want to document that you talked about that, because those are the people who are likely to think that it's your fault the will read the way it does. So have something in your file where you talked about that question. And you don't need to be the spiritual advisor of your client, but it's very positive to have something in your file that says that you actively discussed this and the client gave you a rationale. You know, and as you listen to them, if it's, well, I'm doing this because my son who's taking care of me doesn't like his brother, you got a problem. That's a lot different because you've got a client who's not acting on their own initiative. They're acting in an undue influence situation, and that's a real concern. So it's just a matter of continually monitoring the thing, in my mind.
Bill, under the topic of conflicts, are there instances where joint representation of spouses is not a good idea?
Yes.
And describe that for us.
Well, here's an easy one. If you've got, try to generalize this. Let's say you have an existing client relationship with one spouse, and that prior representation has involved something that's pretty sensitive and might bear, you can fill in the blanks on this, but might bear on how their estate plan's put together. And if you were just representing that person, you would talk through the implications of that situation. Ask yourself, are you maybe willing to have that conversation if so-and-so's spouse is sitting in the room? If you can't fully represent the interests of not only that client, but what if it's something that could spill over onto the other spouse? If you can't get that out on the table and deal with it in the planning, you shouldn't take that representation. That's one example.
Here's another one. You have a client who wants you to do the estate planning for her son or daughter or something like that.
Yeah.
What are pitfalls on that one?
And this is a very interesting scenario, because often it will be a client you really value, that, you know, and it might be someone with substantial assets because they're the ones that care about succession and all this. And they're often the ones that come in and they're doing this because they figure you're going to make sure that they get taken care of, they being the parent. And, you know, so that the in-law that maybe your current client doesn't like is not going to get the family jewels. This situation is fraught because you owe an undivided duty of loyalty to the child, and let's say you're also representing the in-law as a married couple. I have had this request, I have done it, but it's always been under this circumstance. Right on the front end, I say, I'm willing to do this, but you have to understand that I will be representing your child or your child and the in-law. I will be implementing a estate plan they want, and I'm not going to be telling you anything about how this is going or what they do. If they want to tell you, that's fine. And often, you know, in some contexts, like a family business situation, it makes a ton of sense to coordinate the estate plans. But you have to be careful, because if dad, and it's often dad, you know, is trying to dictate and micromanage their child's estate plan and how they think the grandchildren should be treated and things like that, you've got a problem. Because the one thing, and this is hard in the current environment, the one thing that you've got to keep as your guide star in this is that the person you're doing the estate planning for is the only person whose interests you can properly consider in the plan.
You know, that it's, when I look at the claims, the risks for estate planners is great, because we have claims where there's been no representation, no prior familiarity. So you get a cold call, put some paperwork together, send them out, and then the lawyer doesn't hear anything again from them. They don't know what happened. Or the too close situation, which we've seen claims and grievances wherein the lawyer actually inherits a lake cottage or a boat or an antique car, but they're the most trusted and friendly person in that person's life for the last 10 years. Kids are gone, up north, the lawyer's the one that they like.
Yeah.
And the lawyer says, what did I do wrong? They wanted to give me something. But Bill, I know the one easy answer you have in that circumstance.
Yes, and it's the one that's recommended by, I think both by the ethical rules and case law. If your client wants to give you something, and this is distinct from wanting to appoint you as personal representative or trustee, that's a separate consideration. But if they actually want you to get something from their estate plan, and what they want you to get is more than you would get if that person had no will, so it's outside of that family situation, the only safe thing to do is say, I really appreciate it, I'm touched, and you need to go talk to a different lawyer to write this estate plan with me as a beneficiary in it. And there's another consideration here. You don't say, and my partner's right down the hall, or even my former partner's right down the street, because there is case law for the proposition that if you steer the client to a lawyer who's sympathetic to you, you might as well not even bother. So you've got to somehow try to have a blind situation where someone who you know is not going to just wink at you and say, yeah, I'll take care of it for you, Bill.
Well, you can prepare the paperwork and then send
Yes,
them down.
that's right, sure. Yeah, this is very simple, Bob.
No, but
Just-
Well,
just have them
that,
sign it.
that undue influence thing is, you see that in claims.
Oh, yeah,
Right,
yeah.
Brian?
And I mean, it sounds terrible, but I mean, honestly, the lawyer says, listen, I told him 100 times that I feel uncomfortable, and please, but they say, no, you're the only one that I can talk to. You're the one that has been there for me. I want you to get my lake cottage. So the lawyer is just, but Bill's answer is obviously the right one. I mean, the easy one. And you're going to get a grievance most likely at the least, but let alone a claim. But the undue influence issue is such a tough one. Well, I guess the one thing that's maddening for claims, and Bill and I were chatting about this before, is that the lawyer didn't make any mistake. Say they drafted a land contract or a quitclaim deed. The legal description's correct. The client was competent, the intent was there, the lawyer didn't miss any statutes or deadlines or otherwise, actually did exactly what they were retained to do, and then get in trouble because of they got in the middle of a family strife. Sure. And I know, Bill, you already said, what do? You walk away from the deal?
That's the easy answer, but it's not the right one. This is a scope of representation issue, but it's very difficult. You get calls, can you draft a deed for me? What do you say? Well, I'll do it for $100. Or you do it because you know your paralegal can do it for you cheaply, and maybe this is a way to meet a client. And that's 9 times out of 10, that's going to be fine. But what if that deed is actually an estate planning document where, it's part of a divestment strategy you know nothing about? And, as you and I were talking, it might be, at the time, everybody's delighted. But a few months later, one of the in-laws starts snapping at mom or something like that, and now she's got giver's remorse, and it's your fault because you didn't counsel her about this. Well, you just asked me to draft a deed, and that's a defense because you can define the scope of representation as long as you're doing that in a responsible way. The problem is, for something like that, are you going to write a letter saying, this is what I'm doing for you and this is all I'm doing, and I'm not looking at the economic aspects of this or the estate planning aspects of this, I'm just acting as a scrivener for you? Well, you've now spent more on this than the economic return on the deed. So that's a problem, but it's not an easy fix.
Bill mentioned the conflict where an older person is dictating how their son or daughter might have their estate. I think the more usual might be that the beneficiary has a relationship with the attorney, the favored beneficiary that brings mom or dad to the office, and the lawyer's then to blame because you knew this person. That whole conflict thing comes up in reverse. But Bill, I guess the paper in your file and documenting what you did and why you did it is.
Yeah, although I have had situations where it was a two-brother situation, and mom was pretty old and had very substantial assets and was going to disinherit brother, and I told my current client that I was concerned enough about this that I sent him to a different lawyer to prepare the documents, just because I didn't want to become the issue, or as part of the scheme to pull off this undue influence thing because of our prior relationship.
How about fees, Bill? You get into that then at the initial meeting as well?
That's a real thicket, and I don't know how people out in the audience feel about this, but I think I am going toward flat fees, just because it's how to charge properly for this is a real challenge, and there are a lot of people who do estate planning, but it's impossible to properly judge what you're going to charge someone just based on that initial conversation. So my engagement letter now is saying I can't tell you now what this is going to cost because I don't know enough, but I try to refine it further down the road, and I'm gravitating toward a fixed rate, and so far I'm not doing great on that economically, but I still think it's the best way to provide this service.
Do you lose some clients that way? Because I'm thinking clients, they
Yeah.
want to know, what is this going
Right.
to cost me?
Sure, and they, right, because you're competing against a computer program or someone who's got a form, who will throw them a form, but I just can't justify doing that. Because what if you get a step into it and you find out, their assets are much more complex, or, they really need a marital property agreement or something like that, and you've promised to do it for $500. I don't want to be in that spot.
What do you do, Bill, on that when you have a flat fee and you send out your nice paperwork and then you never hear from them again? I mean, is that...
I'm still working on that. It's probably a violation of the antitrust laws, but I'd love to know how people time their charges. But one of the biggest problems with estate planning is getting people to finish it.
Right.
And I suppose there's a risk when you send a document out that people will just run away with it, sign it, and if something's wrong with it, they're going to come back and blame you. Well, I think you've got a pretty good defense that, hey, we weren't finished here, that was a draft. Helps to stamp things draft, just so that that's clear to everybody. I mean, and it's not just a proprietary thing, but as a matter of just keeping your file clean and reminding the client that, we're not done yet. Another reason I do that is because I wish I were a better proofreader, and there'll be typos in there, and I'm trying to tell don't panic. The final product's not going to look like this. My purpose is to get this out to you. See, it says draft, and that helps.
Because we do get that call where the lawyer's concerned that I did this, I haven't heard from them. Am I at risk? I don't know what else you can do, Bill, other than the follow-up calls and letters.
Yeah, and that's, and that gets to diligence, and that's situational. If someone's on their deathbed, you've really got to make sure that you're not the reason their will didn't get signed, I think. And there's only so much you can do, but it's nice to be able to show that you did what you could. I think what often happens is you throw a draft document out even after the initial meeting, and it starts to trigger some questions that are hard for people, like who's going to be the guardian of our kids, and that can start weeks of discussion. So the document doesn't get done. And what if something happens to somebody in that situation? The law is reasonably sympathetic to the lawyer that you're not daily banging on someone's door saying, sign this, because there's also the matter of protecting the client's interest in having the time to make the decision they want to make. It's not good lawyering to force someone to sign something that maybe they're not comfortable with anymore. So I think what you do is you show, and email's great for this, I think, as long as you're sure they're getting the emails, hit the read receipt. We met a couple weeks ago. Is there anything I can do to answer any questions on this? We're not done yet. After a while, you just stop doing that and kind of say, well, maybe they'll come back. And sometimes they do, and sometimes they never do.
How about expectations?
Whose?
Clients?
The clients?
Well, maybe yours too.
Yeah. Well, I think they have to be managed.
They got to match,
Yeah, and you manage them through the engagement letter and through the meeting. And, you have the meeting and you find out what kind of a plan you're dealing with. You think about your calendar and, is it going to take me a week to get a draft to you? Other people may have completely different ways of going at this. My typical process is, I'll get the initial contact, I'll send out the engagement letter. I'll get that back, and sometimes people will have provided me with the sort of the initial financial information, sometimes not. Then I want to see them, if possible. Sometimes people won't even come in anymore. And after the consultation based on what I've got back from the engagement letter, I'll send out draft documents. It's the engagement letter, and then during that initial meeting, once you've got some sense of what this is going to involve, then you can figure out how long it's going to take for you to get back to them with an initial draft. And then it's really up to them, because, you know, they're completely in control of the process. But I think you're setting the expectations in your initial letter and at that first meeting, and then you've done what you could.
You know, Bill, we live in this age of this Geico age where people just feel like they can hop on the internet and get things done, buy things, and whatever it is. So, you know, family law attorneys have seen this for years, and that is, you know, like in Dane County, I think the latest numbers are 80% of parties are not represented. So do you get people who have tried to do their own and you're asked to clean up the mess?
Yeah, I have, although not as much, because I think people are pretty confident that what they're buying with those prepaid, you know, fill-in-the-blank programs is going to take care of them. But I've had, can you just look this over for me? Or this is the worst one. Can you just look over this section? Ding, ding, you know, dive. Because now your client's purportedly defining the scope of your representation, but wait till something goes wrong on the other page, and why didn't you catch that? This is a live question. I know some lawyers who will say to something like that, it's also like the bicycle mechanic who won't repair bikes that are bought over the internet, but they'll say, you know, I didn't draft this for you. I'm not going to look at this. If you want me to do a complete review, I'll do that, but I am not going to, you know, just look at selected provisions. And I think that's a reasonable and certainly from a risk management perspective, a good way to look at it, because the whole thing's got to hang together, and you can't look at one provision in a vacuum and say, yeah, this thing is just fine. I suppose you could write an engagement letter that says, I am looking solely at Article 4 of your proposed estate plan, you know, for this purpose. I don't know if that would even fly. And I don't think any client in their right mind would agree to that. Plus, they're probably already off looking for someone else who'll do it for them for $50.
Yeah, and you touched, I thought your point on client asset information, that is such a, because we see the claims on this. Can a lawyer reasonably rely on the client to gather and report on the information? Do they even know how their retirement and IRAs and life insurance and annuities are, who they're going to? Yeah. And so then are you doing something consistent with their intended plan of distribution? And then that's the claim against the lawyer, that you did something that was entirely different than and not consistent with what they wanted to do, and you should have done more to.
Right.
And it's not so different, I don't think, than the bankruptcy where you're asking people to bring in their debt information. They don't have it right. But it does fall on the lawyer, Bill, to make sure you're getting the right information from the client.
Yeah, and I'm not sure where the stopping point is on that. I am aware of a case where a client came in, told their estate planning attorney that their property was titled in a particular way, and the attorney relied on that, drafted the plan accordingly, and then the testator died, and it turned out the property was either jointly held or something else that kind of blew a big hole in the plan. And there's a malpractice claim that the lawyer should have gone beyond what the client told them. And, you know, and I was talking to somebody about this, do I need to do a title search for every estate plan I do? I don't think that's where we're at, but what I'm doing, and this may come back to haunt me, it's sort of a sense of kind of the quality of the data that's coming in. I mean, you know, if people provide you with detailed information about each asset, I'm pretty comfortable that they're probably right on this stuff. And I'll mention it on the way out too, that, you know, we've got to make sure that your assets are titled in a way that's consistent with your plan. That's another good way to handle this, but it's a little late. But if you're getting, someone hands you a shoebox full of stuff, you know, I think you're kind of on notice then that you might need to do some more inquiry about who owns what, how it's held, and kind of what it's worth.
Now, what if the client is your mom or dad and they want you to do the will? That's the other one I wanted to get, because we have those claims, and they say that's the only, either I'm going to LegalZoom or I'm going to you because you're my son. And is that prohibited?
No, it isn't. But, you know, there's case law, and I can provide the site if anybody's interested. There's a Supreme Court rule that says when you can do that. and it's got this multi-factor test, but there's a case that really, I think, just cuts to the chase, and it says a lawyer shouldn't be drafting any will where they're getting more than they would get under the laws of intestacy. So if, in my situation, it's pretty easy. I'm an only child, so, to my knowledge. And, you know, so a plan that gives everything to me is not going to cause me any sort of ethical problems. But if you've got a multi-family situation and someone's not getting an equal share, you and anybody in your firm probably shouldn't be drafting that document.
Yeah, one thing I want to note on that, just to get the junky insurance stuff out of the way, is the claim that you'll get from sister is that you committed a fraud or you intentionally misrepresented certain things, and it's getting away from negligence and into non-covered and claims and punitives and those kind of things. Another risk why to say, I'd love to do it, I'm not wanting to face an uncovered claim down the road, because they do always, those claims become more of an intentional misconduct type of allegation, that you intentionally misled mom or dad.
Sure.
And
That's a good point, Brian. And there's another thing that can be pointed out at this time, is that the progression in these things tends to be, and we've seen this too, is disgruntled person files a lawsuit, makes those allegations, eventually loses, and then they file a grievance. So, you know, when you're thinking about practicing defensively, you want to not just be sure you can win the malpractice claim against you, you want to avoid having a grievance filed, because nobody likes that. It's unpleasant and very unsettling. So if you practice defensively enough so that the grievance wouldn't even have any merit, because you can't stop someone from filing one, then you're going to be okay on all fronts.
Quick note, you cannot contract someone's right away from bringing a grievance. We've had claims where we settled the dang claim, and then they bring a grievance, and the attorney's really upset, but ethically you cannot prohibit someone from filing a grievance, even if you resolve their legal malpractice claim. So.
And that's so easy, you know, that's a letter. If someone looks up the OLR's address on the internet, they file a letter, and then you get a letter.
Most of them don't go anywhere, but.
No, but you've got to respond.
Yeah.
And if I can just say that, always timely respond. It's the last thing you want to do, but it's the first thing you should do, because the worst thing you can do they're no different than any other administrative agency. If you ignore them, they take offense, and then you go to the top of their list.
Especially when the grievance is procrastination and he never got back to me. You're kind of building their case.
All right, Bill, how about updating plans, and also someone comes in, you don't know if there's an existing estate plan already out there.
Yeah, that ought to be in your engagement letter set of questions. Do you have any of the following? Rattle off, look for the estate planning stuff. There's a lot of, in my practice, there's been quite a bit of updating with the estate tax exemption going way up, and lots of people who had substantial assets but not astronomical amounts going, do I need, you know, the credit shelter family trust mess anymore? My kids are fine, they can just have it. So there's a lot of people coming in, you know, can I just take this out? And there it is again. You don't need to look at the whole plan. I just need to know whether we can get rid of this section. I think that's just fraught with peril. I think you got to tell people, look, if we're going to do this right, you need to permit me to look at the whole document and suggest other things, because it's all tied together. You know, and the rule of law in professional liability is sort of the last attorney to touch the file sort of owns it. It's, you know, it's the Seltrick case. Even if you can't, as a defense, say, well, I didn't write Article 3, the prior attorney did. So I'm not liable for the fact that the will I wrote that just copied that contained the same fault. You own it. And I think, certainly from a claims perspective, you've got to assume that any estate plan you're working on, you're on for the whole thing, unless you could write an engagement letter that very carefully circumscribes what you're doing. And even then, I'm not sure that works.
So in estate planning, limited scope is just not something that...
Well, yeah, you can sure try it, but that might keep you up at night.
Bill, we had a claim recently where the lawyer, this is getting to file storage and upkeep, but they have a bunch of original wills and had no idea that someone had died. And they found out when they were actually sued and named personally for failing to deliver an original will per WISTATS 856051, which I was not familiar with until that very claim came in. But it brings me to the thought of, you talk about keeping all these file materials. Do you keep original wills at your office?
Yeah, there are two considerations here. First of all, there is law for the proposition that lawyers should not encourage the safekeeping of their clients' original documents. Goes back to the old Golbakian case. The idea is that if that the client who gives you their original will is telegraphing to whoever's going to probate that will that you want to use this law firm. So it's not that you can't keep clients' original documents, but it has to be an unsolicited request from your client. And we do that as a service for people if they initiate it and we're sure they don't have a safe deposit box, and wouldn't you really rather? And then we say, well, okay, we'll do it. But you're right, where does that leave you? Because there's a statutory obligation to deliver a will to the probate court within a certain time after you become aware of somebody's death. So
60 days.
yeah,
I I knew that all along.
I thought this might come up. It's 30 days after you have knowledge of the death of the testator. And if you fail to perform without reasonable cause, you're liable in a proceeding in court to every person interested in the will for all damages caused by the neglect. Now, I'm sure, creative plaintiffs' lawyers can find all sorts of harm coming out of that, but the bottom line is, what's reasonable effort to determine whether someone whose will you've got has passed? Our practice is that we have our receptionists look at the obituaries in the State Journal every day. Is that adequate? I don't know. I think so. I think that's a reasonable effort. People move to Florida. We can't really track them all over the world, but that's what we're doing. And yeah, we keep originals for forever in a fireproof box.
May I ask a question?
Yeah, go ahead, Bill. Hang on, Bill. We'll get you on the microphone. Up front here, Katya, so the internet folks can hear you. Go ahead.
Thank you. Why wouldn't you just tell your client to pay the $10 or $20 and file it with the Register and Probate and be rid of all of that administrative watching obituaries and hoping they're still alive and that type of rigmarole?
And that's a reasonable position to take. We don't do it because it's a matter of client relations, but we also realize that entails all the headaches that come with it. But you're right, that's a perfectly reasonable position. We do have people, though, who will say, I don't want to file this with the court. You can tell them nobody's going to look at it, but they don't care. We've got some people who are very conscious of their privacy, and that's, when you offer them that option, that's a non-starter. So, I mean, we'll do it, but you're right, it would be, I prefer not to, and I actually tell people that, but I will do it for people who kind of insist on it.
Anyone else? Okay. Where else do we go? Before we get into tax considerations, what about, and I know you guys have hit on some of this, but any other information that you should get from the client? I know I think you talked about marital status and things like that, but, and you talked about asset information. Anything else that we should cover on that? Heirs, all those things that are out there?
Yes. What do you have, how do you hold it, and what's it worth? And you'll get a range of responses from people who can tick that off precisely to, what do you mean, how is it held? And then you've got to look a little further. For a lot of people now, their most substantial assets are assets that will never pass through probate. Their retirement plans and their IRAs. If any of you represent physicians, that's where their wealth is. It's crammed away in these beautifully designed deferred plans, and it's lots and lots of dollars. And people tend to fixate on the will, and sometimes lawyers fixate on the will, but from a dollar perspective, the most important part of a lot of estate plans is the qualified plans. And you ask people, who's the primary beneficiary? And they might know. And you ask them, who is the secondary beneficiary? And they don't have a clue. And they've got a spouse and 2 minor children. And so you're looking at a scenario where if mom and dad are killed in a car accident, you've got minor children who will suddenly become possibly beneficiaries of millions of dollars of individual retirement accounts or something like that. If that happens, it better not be because you didn't ask the question about what's your plan for all that money if your spouse doesn't make it. So that and a lot of people too, it's surprising. You'll talk about their estate plan and do you have any life insurance? Well, does that count? Is that part of my estate? Well, yeah. And who are the beneficiaries? It's the same thing. Who's primary, who's secondary? And you've got to work that through.
Yeah, and we've seen the claims where the couple wants to the individual wants to have their estate divided evenly between 2 beneficiaries. And then it's $1 million farm and a couple of $1,000 with an account. Back to your point about understanding the value of the assets, because you might not be doing what they want you to do, and they don't understand that isn't going to be equal without your help. And there's the claim.
Yeah.
Yeah.
All right, questions? Tax considerations, Bill?
Yeah, I thought it was worth talking about this. I know there are people who will say, I do estate planning, but I don't do tax stuff. And I refer people to an accountant if there are any tax issues. I think that's fraught with peril. I'm not saying that you've all got to school yourself in the generation skipping transfer tax, which is a guaranteed headache, and all of those subtleties. But I think that regardless of the size of someone's estate, there are a couple of things that you need to have on your radar. The first is, are you sure there's no estate tax issue? People, it's kind of strange, but people often tend to undervalue the value of their estates. And one big way they do it is they don't count the life insurance, which, as you know, presumptively is in unless you've found a way to keep it out. You'll run into people with, and I know these numbers seem stratospheric, but there are a lot of people in this state who have more than $5 million. So, you've got to start thinking about that. And is there a state under because they made substantial gifts that maybe were taxable gifts? They might not even be aware of the fact that, if you make a big enough gift, it goes against your exempt amount. You got to make sure you've got that, because if you have a taxable estate and you didn't know it because you didn't ask the right questions, I think you've got a problem. Property in other states, if somebody, do they own property in New Jersey, which still has an inheritance tax, although I think they're phasing it out. So I do think you got to quickly check off that no estate tax issue, and for a lot of people, there isn't going to be one. But I do think you just have to kind of check that one off. There are income tax issues that are very important, that even if you don't do tax, you've got to at least be aware of these issues. And that's the impact of making a gift during lifetime versus a testamentary gift on the tax basis that the recipient of the asset receives. Because now that estate tax doesn't worry most people, the game these days is to get that basis as high as possible in the hands of the ultimate recipients. And if someone says, well, I want to give the kids the farm now, you've got to say, that's nice of you, but did you know if you hold it until you die, they'll take the date of death value as their tax basis as opposed to what your basis in the farm is. And if they still want to do it, that's great. But you should mention somewhere, maybe in an email, maybe in a letter, that you talked about that, because that's a huge one. When a client or a client's heirs find out that they could have gotten the farm with essentially no income tax issue and they're just looking to cut and run on it and sell it right away, they might be asking you some questions. Likewise, marital property is handled differently than property in common law states with respect to basis adjustments on the death of the non-titled spouse. If that's Greek to you, it's either because I didn't express it right or you're not familiar with this, but if an asset is held as marital property and one of the spouses dies, the surviving spouse takes a new tax basis in that asset equal to the date of death value of that asset for the whole asset, not just the half that was included in the decedent's estate, but their basis gets bumped up too. This is a loophole that is still in the tax law, and for as long as it lasts, you need to be cognizant of this, because most people are fine classifying everything as marital property, and if they're willing to do that, there's a huge income tax advantage for the survivor. If you don't at least go over that with people, I think you've got some exposure. And the last point on that is you do not have an affirmative duty to compel your client to put together an estate plan that minimizes death taxes. People's children would like that to be the rule, but that's not the law. What you need to do is inform your client and let them make a decision. And my experience has been, everybody's got a different threshold. Some are, I will do whatever it takes to zero out the taxes on this situation, or get the maximum possible tax advantage. Others are like, and I've literally had people say this, I'll be dead, I don't care. So don't bother me with all this. And that's great. But make sure that somewhere you can show that you at least brought the issue up, so that if the heirs come back and say, why do we have this lousy basis in these assets when it could have been so much higher, you say, because that's what my parents wanted.
Yeah, I had the note of estate planning or tax law. Is there a difference? Because beneficiaries, we've seen the claims where they think that the lawyer actually, their only job is to minimize the tax exposure. And so that is a good point by Bill, and I think it also heads into this ORIC idea, because we've talked all about it, all these claims coming from non-client beneficiaries. Bill, you're at least a little more optimistic that it's not 100% liable for to everyone that has a trust deed. Non-clients coming out of the woodwork. You want to explain your take on that? And
Why am I not hiding under a?
Yeah.
Well, there are a couple of reasons. One, there's a difference between what individuals hear and what the plaintiff's bar thinks the law is, and the law as it's actually being enforced. And if you read the cases that follow ORIC, it's pretty clear that the courts recognize that we can't get into a situation where an estate planner has divided loyalties between their current client and the heirs and prospective beneficiaries of that client, because those interests don't always align. And what is owed by us as estate planners is undivided loyalty to the person whose estate plan we're doing. And often that's, getting things to the children in the best way possible. But sometimes parents' plans don't coincide with what the kids would like or what would be in their best financial interest. And
Bill and Brian, maybe for those not familiar with the ORIC case, normally in a malpractice claim, it has to come, you have to establish lawyer-client relationship. And maybe you guys can go through ORIC and how that exempts estate planning so that non-clients can bring a claim.
it's a flat-out exemption to the privity rule. And it provides that under certain circumstances, a non-client who was the intended beneficiary or beneficiary of your client can bring a claim against you for malpractice. It's
or thought they should have been.
right, right. Yeah, I mean, anybody can bring a claim. But the actual grounds for that are carefully circumscribed. It's the plaintiff has to be able to show that that the testator's clear intent was to benefit the beneficiary. So the fact that someone is not named in a document doesn't give them an ORIC claim. The classic ORIC claim is where the scrivener of the will forgets to write in a paragraph that there's no question that the testator wanted, say, the family cabin to go to John Doe. And because of a transcription error or something, that paragraph just gets dropped. John Doe's got a claim against the lawyer for that.
And or the situation where that's not properly executed.
Right.
The document, so it clearly outlines the intention, and because of an error, not having two disinterested witnesses, it's not hard to make that claim.
Right.
In that circumstance.
But where we see this claim is where the disappointed heir thinks, I didn't get something I should have gotten, so it's the lawyer's fault.
Right.
And that's not a valid claim.
But ORIC doesn't turn the kids into your client.
No, and that's if there's a takeaway from this, don't let your fear of or your concern about liability claims take your eye off the ball. And your client is the person you're doing the estate planning for. It is not their heirs, successors, or potential beneficiaries. And if you stick to that and document situations, if where are the flags? If someone's getting less than everybody else, you want to be able to show, and it could be years from now, that that's exactly what the testator intended. Another real concern area is if you keep drafts, and between draft 2 and draft 3, one of the kids gets written out of the will, make sure that you can show that that wasn't a drafting error, that was exactly what your client intended, and you'll be okay, because that's, as soon as that file gets available, someone's
in
going
that circumstance, would you include a line wherein it's clear that that is the intent?
Yeah. If someone's disinherited, they're expressly disinherited in my documents. And this is another, just quickly, people wonder whether they should go into why. I don't think that's a good idea, because it almost makes it a conditional bequest, or at least something someone can argue about. Because if you say, I'm giving nothing to my son Adam because he's got other assets. Well, what if at the time of death, Adam doesn't have adequate assets? Does that put into question whether that disinheritance is valid? You don't need to go there. You just say, some people will say for reasons sufficient to me, I just say, I intentionally leave nothing to my son Adam. I leave it at that.
Or you can intentionally leave $1 like we had a claim.
Yeah. Problem with that is if you leave them $1, they're a person interested even after the will's admitted to probate. So you've sort of invited them to the table. I think that those nominal bequests are a bad idea for that reason. And sometimes people will do it for spite, and I try to talk them out of it.
Definitely.
Just for that reason. Because, they're interested if they're an heir, but once the will's admitted, they're out of the picture. If they're in the will, even if it's for $1, they're still in, and can make trouble.
That's really mean.
Yeah, well, it's a tough world out there.
Brian, have you seen claims where a plaintiff's lawyer has kind of stretched ORIC to try to?
And as it turns out, Bill helped us defend a case wherein the lawyer was blamed on the divestment, which is part of your comment here, where the lawyer had somehow had a duty to make sure mom transferred the property within 3 to 5 or 5 years of her death, and didn't do a fast enough job or a good enough job. Yeah. That obviously isn't benefiting mom. She's given up her interest in the home, and that mom was the client. And then you're blamed by the kids for the fact that they had to pay for her care because she lived longer than they were hoping.
Right.
I mean, and this was a real.
Welcome to the jungle. Yeah, and that case was tougher because there was a draft deed in the file.
Yeah, and this was another one where the lawyer sent out the paperwork and then mom didn't get back, and But I mean, that's just the can of worms there, Tom, where all of a sudden your client, you want to get rid of her only asset, that's your job, and then be blamed that you didn't get rid of it fast enough because she had money that could pay for her care, but we didn't want to use any of that. But that's where and that's maybe one where the lawyer would have been better off just taking a step back and realizing who's calling the shots. It's like who placed this order? It's like you're at a fast food restaurant. This wasn't mom that placed the order. This was greedy, and as it turns out, well, we won't even get into that case. There were too many turns in that case, but it was not mom, and it was not in mom's best interest to give up her only asset where she lived, and
Although the plaintiff certainly thought it was in
Oh,
his
yeah.
best interest to have it done that way, yeah.
and blame the lawyer for
Yeah,
not doing it.
right,
And
that's
doing
right.
it fast enough.
So,
I wanted to touch on file storage a little bit, and Bill, you mentioned a little while ago that you pretty much have kept everything. So I'm imagining a basement at your office of like 40 years of well, I shouldn't say 40 years. I didn't mean to age
it's
you.
a separate building that we rent.
Is it?
Yeah, and that's,
So
doesn't make us very popular, and there's got to be a better way to do this.
Yeah, and maybe you both can address this, because I know, Brian, you probably have gotten these questions too. We get questions from lawyers, how long should I hang on to my files? There are lawyers who sometimes call us and say, I've got, boxes and boxes and boxes downstairs in the basement, and I don't know what to do with them.
Yeah, and I'm glad, Tom, it's a good question, because before even getting to that, the call we first get is, I did a will, I don't even remember it, 10 years ago, I just got a call, there's some problem in the estate, and they want me, I've been subpoenaed to testify. I don't even know where my file is, but assuming you do, I want to just touch on that, Bill, about, there's been a change in the dead man statute. Your client can't tell you can't testify, and often it's in your best interest to say, here's exactly what happened.
Right.
What can you do ethically? What can you provide to the court and or the other side that's looking to
Yeah, I
discredit the work you did?
just happen to have some thoughts on that. That's, you probably think, well, my client's passed, so there's nobody who can waive the privilege. Well, you're wrong. First of all, if you're in a spot where you're short on people, so you serve as a witness, there are two ways that you've sort of opened things up. If you sign the standard self-proving will, you're making a representation that you believe the testator to have been of sound mind. So that's going to come in. But once somebody passes, their privilege doesn't die. This is interesting. A decedent's personal representative succeeds to the decedent's attorney-client privilege, and that's in WISTAT section 90503 sub 3. So if there's an ongoing estate, the personal representative says, give me the file, you've got to turn over the file. Often that call that you're talking about comes in before someone's been appointed, though. So then what happens? Well, the privilege doesn't apply if there's a claim of a breach of duty to the client by the attorney, or with respect to an issue concerning a document as to which the lawyer is an attesting witness, so it goes beyond the will, or as to a communication that's relevant to an issue between parties claiming through the same deceased client, which is pretty much every will contest you've ever imagined. So if you get a subpoena and say, well, this is easy, I'll walk in and say, I'm sorry, this is privileged, and can I leave now? You're going to be there a little longer than you think, because the privilege probably isn't going to apply. Now, what you might get is a call from somebody who's saying, I'm going to petition to get this estate going, give me the file. You can't do that. You've got to be sure that whoever is asking for that has got either the authority to assert or waive the privilege of your former deceased client, or that it's a context where one of these exceptions applies.
One thing on that I want to note is a lot of times people will practice estate planning work because they don't want to be in litigation, and they don't care to litigate, and they don't know what's going on when there's a litigation matter. When you're getting that call, and it might be a real friendly call, this is a bogus claim from the son that was a terrible guy. We just need you to verify why you did what you did when you signed. That's a potential claim, because what you're having is this son's claiming there was undue influence, or that dad didn't know what he was doing, or was incompetent when he executed the will. So you should put your carrier on notice, and I'm not doing the WILMIC sales pitch, although if you're our insured, please do call us. You can chat with someone like a Bill and make sure, what can I say, what can I not say, because often it's after the deposition or the testimony that you think, oh, that wasn't so comfortable when I sat there, because it sounded like they think I did something wrong. Make sure you want to report it. It may not go anywhere. I would want the help and guidance if I was in that area of law, and I'd want someone to help me know what I can or cannot say. report. It's a potential claim. It may be bogus. It probably goes nowhere, but if someone's challenging the work you did, claiming the will is no longer valid because of X, Y, or Z, that's a potential claim, and you need to report that to your malpractice care.
We have a question from a webcast viewer. Do you keep original documents, Bill?
Yes, we do, if the client asks us to, and only under that circumstance.
Otherwise you don't?
Otherwise, we don't.
And what's the thinking behind that?
Well, we send the originals to the client.
You do?
We
Okay.
Get them off-site. Because once you've got, well, with estate planning, once you've got an original document, you've got to keep it until forever. And that leads to the warehouse that we rent down south of the Beltline.
Karen, yes.
Just a follow-up, can you hear me? Do you keep the drafts as well?
I do. And that's a judgment question as well, and it goes back to, and I don't know if your question is, do I keep paper copies? I mean, more and more, I'm just keeping the electronic versions of those. That's a judgment call, but I was thinking about this with my former partner, who's deceased now, I guess makes what he said to me more relevant, but said, you're almost always better having the documents than saying I destroyed them. And based largely on that, I keep the drafts. And realizing that sometimes that means you've got to explain, have some record in the file as to why they're different. But I do, just because for one thing, it shows the progression, and I found it useful.
Another question right over here.
When you talked about the estate planner has to have some minimal knowledge of tax considerations, and I know how complicated Title 19 and divestment is. Is there some affirmative duty that you have to discuss Title 19 with the clients? I mean, have you had any claims? Well, no, I know that you said there's something about it. A deed didn't get done, but that was a case where divestment was at least was considered. But I mean, do we have some duty now to at least explain divestment and Title 19 implications?
I think you do. I mean, you're going to run into a claim where you're criticized for not, if it's not in your file, and that's maybe, if that's not up your alley, refer or consult. But I think to not even mention that would be potentially an issue where you could be faulted on a claim. It's a convoluted, maybe that's one of the things, if I'm not into divestment and Medicaid issues, I'm not feeling comfortable if that's your goal. But there would be plaintiff claimant type attorneys that would say that estate planners that don't at least address that would be missing something that should be talked about with the client.
That's a really good point. I mean, some clients, it's going to be, they're not in a position to divest because they've got substantial assets. That's the easy one. But anytime somebody's not got very much, and I'm hoping that it's sufficient to say, this is not a divestment plan, and this will not help you, and that's not what you asked me to do. But it's a very good point to be able to document that you at least told them that that's not what they were getting from you.
Okay. We have about 5 minutes left with these guys, and then I'm going to bring Matt and David back up here for a final kind of wrap-up. For you, Bill, in these last 5 minutes, let's talk about following through, finishing up, post-document signing obligations, all those sorts of things. I know that's very broad, but let's kind of walk through some of that stuff, if you don't mind.
No, sure. And this is as important as the engagement letter is coming in. The sort of exit letter is really valuable, and it's the last thing you want to do because you're done. Finally got them in here and they signed it. Great. This is another opportunity to deal with some important issues, and you'll say, here are the documents we did and where they went. You have the originals, I have the originals. You got it in the file now when someone says, we can't find Dad's original will. What did you do with it? You look at your letter and said, I gave it to Dad. You're done. This is your golden opportunity to point out that if there's any asset retitling that needs to be done, and you've talked about that, and the client's going to do it, you put that in writing so that if they set up a revocable trust and don't get the assets over, no one's coming back to you. Likewise, check your beneficiary designations. And the way I phrase this is, don't check your records for the form you sent. Contact the insurer, the plan administrator, and ask them what their records show are the beneficiary designations. Then the last thing that is very difficult is how you end this letter. Is it, you're my client now forever, or are you now a former client of mine, and if there's a conflict situation, we'll look at you that way. Nobody likes doing that because, hey, if they've got other work, you want them to come back. On the other hand, if you're doing that, then I think in the client's mind, you are their lawyer. So they are a continuing client of yours for conflict purposes. And I think you got to make a conscious decision on that. But
Yeah, and then the risk of wanting you to update them about changes in the law and how that might affect their estate. You've opened that door
yeah,
by leaving that open.
right. Just quickly on that, I have come down on the side of telling people I will not be sending you periodic notices about changes in the estate tax law because I don't know enough about my clients and their ongoing situations to responsibly do that. I mean, people send newsletters out, and I don't know if that creates an ongoing client relationship or not, but for better or worse, I've come down on the side of saying, if you have questions, contact me, but otherwise, keep an eye on the law because I am not going to be advising you from here on out about changes in the law because I just don't think I can responsibly do that.
We have an internet question?
You do. You have one internet question that says, once an estate is probated and the court file has been closed, how long does the lawyer need to keep the file, and can the lawyer put a line in the fee agreement that says when the file will be destroyed?
We should probably repeat that since you weren't on the microphone.
Oh, shoot. That was the rule.
Want to make sure, though, since it's a web question.
Once an estate is probated and the court file has been closed, how long does the lawyer have to keep the file? And can the lawyer put a line in the fee agreement that states when their file will be destroyed?
I think so. I still, if I've got original documents, I'm probably never going to get rid of them. I would either ship them back to or ship them to the then former personal representative, and then I think your standard file retention policy can fairly apply if you've got that situation where you've been through the end of the probate or the administration process. Then I think you can go for that 6 or 7 years. But it's just hard for me to get to shred an original document ever.
Okay. Any other questions from the folks here? Anything else on the internet?
No.
Okay. Thanks, Katya. All right, so we've done 75 minutes on each. I would welcome any bankruptcy questions for Mr. Krekeler or Mr. Beier, any estate planning questions for Mr. Williams, claims questions really from in either area for Brian or Matt. Anybody have anything you want to throw out there now that we're ready to wrap this up? Anything we have not covered that you'd like to hear about? Okay. Yep, we got one right here.
Suppose the documents are signed in the estate plan, 10 years go by and the attorney retires, 20 years go by and a claim of some kind comes up. How does tail coverage work? Does it just go on forever, or how does one protect himself against that?
Yeah, you can get, the key there would be unlimited tail, which in estate planners, that would be the way to go. I would say it's a little more expensive. You can get shorter tail periods, but an unlimited tail would cover you in that circumstance for on and never after.
The tails, we have tails that go 3 years, 6 years, as Brian said, unlimited, so it depends on what kind of a tail you've purchased. Unlimited would certainly help you sleep at night.
Sounds like in estate planning it's pretty loose as far as how many years you have to worry about.
Right.
Yeah, I think that's an area that many years can pass.
Yeah,
Katya?
because it's 6 years from discovery.
Right.
So they're not going to discover this until, what did you say, the estate plan matures. And for those of you that don't know, tail is sort of a
fancy little term
shorthand
that we.
way. It's an extended reporting endorsement, so it gives you additional time after a policy ends to report a claim. It's not for work that you do after a policy ends, but it's for a claim that arises out of work that you did before. So when you retire, in order to continue the option of having coverage for work you did while you were practicing for claims, like estate planning claims that come in 20 years later, a tail or extended reporting endorsement is the way you protect yourself.
And I should mention, this is Katja Kunska, our president and CEO. She has been president for the last 13 years and with the company 28 years. So she just didn't walk in and start answering questions. I wanted to, make sure they have your, resume a little bit. Okay, anybody else? All right, my question to wrap things up, and I'll start with you, David. We've talked a lot about the many rules, how things have been changing, keeping up with them. That's where bankruptcy lawyers can get tripped up. Estate lawyers, the same thing, keeping up with the changes in law. So my question is kind of from the 30,000-foot view. The practice of law generally is changing very rapidly. What I've seen, some statistics are, and some so-called experts believe that we've seen more changes in the last 10 years than in the previous 50. And I think we all agree that things are moving so fast. So where do you see the profession going? What would be your take on how lawyers, either bankruptcy lawyers, estate planning lawyers, or any lawyers for that matter, how do you move into the future in this profession? Do you embrace these changes as opportunities? Do you call it quits and run for the hills, or what do you do?
Well, I talked to you about a Chinese general named Sun Tzu. Now I'll move to Greece, and the philosopher Heraclitus said there is nothing permanent except change. And I totally believe that, and I think you're right. I think we're even seeing an acceleration of change. Those of you that aren't into philosophy maybe know Yogi Berra, the Yankee catcher, and he said, the future ain't what it used to be. So that's a more down-to-earth way of adopting that Greek philosophy. I know change is going to happen. I've seen it a whole lot in bankruptcy. We're seeing it in, gave you some statistics about the Telephone Consumer Protection Act. Change is inevitable. I like to embrace change. Sometimes I catch myself not wanting to do that, but I believe the correct approach is to embrace change. If you embrace change and find a way to profit from it, you will be better. In fact, think about this. Can you improve without changing? And the answer, of course, is no. So I say, bring the change on. Let's find a way to use it, adapt to it, and improve and get better.
All right. Bill?
I can't possibly be more articulate than that, but in estate planning, I think the biggest recent change, aside from the sort of the malpractice climate, is the electronic exchange of information. And that's got two consequences for us. One is it does enable you to serve your clients better. You can, instead of passing things back and forth through the mail, you've now got email, and as long as you're handling security properly, you can get documents to people to review. They don't have to print stuff off. You can share drafts more readily, and I think that's positive. And I think the give and take that email provides in the estate planning context can be very positive. The flip side of it that we have to be mindful of is that this electronic information exchange has led people to expect, and this is true about the law generally, immediate response. And that is not what this profession is about. So this is where I think we have to stand athwart of the tide and say, look, this is not a question that an answer process where I'm going to get back to you at 11 o'clock at night if you fling a question at me. My responses will be as prompt as they can be, subject to my deliberate and thoughtful reply, and I need some time to do that. It's another thing to manage at the beginning of the engagement, is that this is not going to be banter, text message back and forth kind of planning. You're going to ask me questions, I'm going to think about them, and I'm going to give you a response, but it's not going to be ping pong.
All right. From a claims perspective, Brian and Matt, what do you guys, how do you see this going?
two things in estate planning is, we've covered them, but really it comes down to this. Always remember who your client is. Never let an aggressive beneficiary call the shots. That's one. Two, never let your client's sense of urgency override your concerns regarding their competency, their understanding, the impact on their estate. You're on the clock the second you say, I'm going to take this. If the person's in the hospital and you're going on vacation, that's probably not a good matchup. And it's a long statute of limitations. Your question was perfect. It's a long statute of limitations. What's your mature line? We're maturing as we sit here, but
Yes.
but so you don't step into something where you have to do something in 1 hour that's going to put you on the hook for the next 40 years. Just take a breath. Communication's never easier, but it doesn't change the standard of care.
Matt, just a couple comments. One, as far as the FDCPA is concerned, one of the things that we didn't get a chance to talk about was the inconsistent interpretation of it, not just within circuits, but within district courts as well. Be aware of where you are, where you're practicing, what the judge that you're before has currently, what his or her position is on it currently, and know it, so that you're making the best argument that you can. And then I guess I would share just generally, not necessarily specific to the FDCPA, but a recent article was shared with us by Katya, who I believe got it from George Brown, and that was a discussion about crowdsourcing and blogging. Maybe not things that we talked about even 3 or 4 or 5 years ago, but certainly are relevant today. There are a lot of people out there doing the same thing that you are, and they talk. And they talk all the time about the changes and how best you can adapt your practice to it. So along the lines of embracing change and doing something about it, talk to other people. I want David to have a very big breakfast bill. So take him up on his offer to take you out to breakfast and just have a conversation about the changes in the law and how you can be a better attorney.
All right. I liked your Yogi Berra quote, David.
David
And
did say coffee, though. I don't want his bill.
just coffee?
Yeah.
Okay.
No, he's a bagel.
All right,
Danish
all right.
or a bagel too.
Okay.
You know.
Well, I wanted to mention, this might be appropriate for estate planning. Yogi Berra also said, I always go to my friends' funerals so that they come to mine. And we do have an internet question. Katya, I think I have it, but you can tell me if it's something else. The question is, can you please explain how we get CLE credit for this program? Was that
No, there's a question about the dead man statute.
All right, let's do that one first.
Okay.
And then I'll answer the CLE question.
So the question is that the dead man statute was mentioned, but the dead man statute has been repealed?
Yes, it has.
How does this affect what an attorney may disclose?
I think it has more of an effect on how we can defend claims than your duty of disclosure. The dead man's statute, everybody seemed to hate, was a good friend of ours in a couple of cases because people had no way to prove their entitlement to an interest in someone's estate except to say, well, the testator told me I'd get this. And the dead man statute kind of put a kibosh on that, but now that's not available. So people are going to be able to say without, it was just the two of us, but he told me I'd get the whole thing. That's going to be admissible evidence now. So I don't think it affects what we can say. I think it affects how claims are going to come in.
So Bill, you say that the repeal of the dead man statute is a reason to buy professional liability insurance?
I certainly do.
Thank you.
All right, there's our pitch. The other question that came through on mine, Katya, was the question was explain how you get CLE credit for this program. You included when you file with the Board of Bar Examiners. If you go on their website, this program will be listed in there as approved for 3 ethics credits. And so when you report, on your reporting form, include this program and you will get credit for it. We do have a list of those who attended both on the web and here. That's usually never an issue, but if it were, we would certainly vouch for everybody who attended. So if you have any other questions about that, feel free to contact me at the office. I'll be happy to walk that through with you if you need it. So hopefully that answers that. Anybody else? Any other questions? web or otherwise. All right. I want to thank our panelists. They were terrific. Please give them a round of applause. Thank you all. You guys were great. You have an for those of you here, you have an evaluation form in your packet. It'd be great if you could fill that out. We do read it. We try to take your comments and improve our programs in the future. Those of you on the web, you will be getting something electronically by email to fill out. So with that, thank you all very much for attending. Have a great Friday afternoon and a great weekend.